Please rise. The justices of the Appellate Division, Supreme Court, First Department. All persons having business with the Appellate Division. Draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon, lawyers. Okay. No spiel today. It's still raining, so maybe just to let you know to please ask just for the time that you need, not the time that you want. Remember, we've read your briefs, the records, quite familiar with your cases. So, People versus Jagnandan. Good afternoon.
Your Honor, I'm requesting a total of 8 minutes, 6 minutes, and 2 minutes for rebuttal, please.
Okay.
Respondent requests 5 minutes.
Okay, I'll do 5 and 2 and 5. Okay, FX funding versus Fox RX. I understand appellant is running a little late. I decided to give appellant 4 minutes and 1 in rebuttal. Respondent Fox RX?
Yes, Your Honor. I request 3 minutes.
3 minutes, there you go. B. Jahira is submitted. Then we have 2 appeals in Acevedo versus Gray Line, New York Tours. We're going to argue those together, correct?
Yes.
Okay, so let me first hear from Appellant Acevedo. Yeah, I'm surprised. Did someone register in? Yeah. I tell you what, let me go through the calendar and I'll call this case again, okay? So, Star Indemnity versus Corcoran Group.
Good afternoon, Your Honor. 6 minutes and 2 minutes.
I cannot hear you, and I assume you're the appellant?
Yes, I am, Your Honor.
Okay, tell me how much time do you want?
6 minutes and then 2 minutes.
6.
Request 4 minutes, Your Honor.
Okay, I will do 5 and 2, although I don't think you'll need all of it, and then respondent will get 5. People versus Shaw, appellant Shaw.
5 minutes plus 1 for rebuttal.
5 and 1. 5. Okay, please keep your voices up. Shah versus New York State Industrial Board. Let me hear from Petitioner Shah. Okay, 5 and 2. Respondent. Okay, 5 and 2 and 5. MTA versus Westfield. Petitioner MTA.
Yes, Your Honor, request 10 minutes and 2 for rebuttal.
You're not going to need that much time. So I will give you 6 and 2. Respondent?
Respondent 6 minutes.
6 minutes. Thank you. W. Lance is submitted. Tishman Construction versus Zurich. Let me first hear from appellant Old Republic.
Appellant requests 7 and 2.
7 and 2. Okay. Let me hear from the others.
Yes, sir. For respondent Tishman and Riverside, 4 minutes.
Yeah, I can't hear you.
Sorry, for respondent Tishman and Riverside,
Okay. Can't hear you. 3 minutes. 2 minutes. Okay, 7, 2, 4, 3, and 2.
Respondent 5-star, 2 minutes, thank you.
Okay, People versus Alvarez. Yeah, folks, please, you have masks on, so it's very difficult to hear you. Please speak up. Alvarez, 5 minutes, 5 and 2, you said? Okay, let me hear from the people. 5 minutes, thank you. Okay, we have 2 cases that should be argued together. Antros North versus Pavlov.
The appellant is Sherry Pavlov, Your Honor. Good afternoon. 7 to 3.
Okay,
Appellate, Mr. Schwab, 7 and 3.
one and one, you said? Okay.
Respondent Amtrust, North America.
I'll give you 7.
Respondent across 5 minutes.
Okay. People versus Ferguson. I'm sorry, one more? Which appellant? We have Pavlov is an appellant. I know there was an appellant that filed a notice of appeal, but did not.
No, Your Honor, I thought you were on people
I'm.
But you were on the next case.
Oh, I see. I'm sorry. People versus Ferguson, so appellant is? Okay, I'll give you 6 and 2. People,
Respondent requests 6 minutes, Your Honor.
6 minutes. 6 and 2 and 6. Birdie versus Dinowitz is submitted. Worldview Entertainment versus Woodrow is submitted. First case on the calendar, People versus Jagnandan. I'm sorry. Did we hear back from Acevedo? Okay, so Appellant Acevedo is not here, correct? Okay, so let me hear from, do you wish to submit or do you wish to argue?
Respondents Grayline and Olivero will submit the rest of the panel questions.
Okay, and Redding?
Your Honor, I would request 2 minutes, if that's okay.
You sure?
Unless the board has any questions, I'm also.
I don't believe that we do.
Okay.
Not on a serious injury case. We went through the record, including all of the medical records that were submitted. So I think we're good.
Okay.
Okay, so that's submitted. So first case on the calendar, People versus Jananda. Yeah, something is going. Yeah, John? Bien raro.
Good afternoon.
Good afternoon.
May it please the court, my name is Stephen Preziosi, and I represent Mr. Kevin Jagnandan. Your Honor, the 440 court erred when it held that my client was not deprived of effective assistance of counsel and conflict-free counsel. Kevin Jagnandan had a defense. His defense was, I did not possess the guns, someone else possessed the guns. His co-defendant made statements that his co-defendant possessed a gun holster, possessed ammunition, possessed a bullet,
Counsel,
proof.
was there a video showing your client with the gun?
No, there was not. And, Your Honor, I'm so happy you asked that question, because I want to direct Your Honor's attention to pages 515 through 517 of the record, the closing arguments of the people, where they specifically say, we didn't see a gun, we saw him put something in his pants. Specifically, Your Honor will not see any video where my client is holding a gun. So, starting at page 515, 516, 517, the people are making this argument that on the video, my client put something in his pants. Then they argue he later goes off screen and gives the gun to someone else. I don't know how they came to the conclusion that he gave the gun to somebody else, but the only person seen on the video with a gun is a female. And so, just to be clear, let me clarify, Your Honor. There are 3 guns in this case. There's a .357, a .22, and a 9mm. The gun that we are talking about is the 9mm. So the .357 and the .22, there is no video evidence at all of their existence. They were found in the shop, but there's no video evidence of them. So, and there's no DNA evidence regarding the .357 and the .22. We're specifically speaking of the 9mm. There is no video that clearly shows, or shows at all, that my client possessed the gun, pursuant to their statements, their arguments. They say he possessed something. He put something in his pants. And then the argument goes on, as I said,
But the question is whether there were strategic reasons for what counsel did. Doesn't that sort of play into whether or not there was a strategic decision not to seek severance or contest suppression, et cetera?
And, Your Honor, the acoustics here are just so horrible. I apologize. I'm not hearing everything that Your Honor is saying.
Well, I'm suggesting, wasn't it a weren't there strategic reasons for not contesting the suppression?
No, Your Honor. I don't think there's any legitimate strategy for foregoing a defense. So in two actions by my client's trial counsel, that one, he joined in the suppression of these statements. He joined in his co-defendant's attorney, his father. He joined in that motion to suppress the statements of the co-defendant. That would have constituted the basis, the substance of a defense. 2, even after the suppression, he had the opportunity to say, oh, here's a defense. I should move to sever the trials because the statements as to co-defendant Damian Frazier were suppressed, and he wanted them in. You know, Judge, I should clarify, I believe he had an epiphany at trial, understanding it. He came to the understanding when he had to cross-examine one of the people's witnesses that these would be great statements to put in to deflect guilt onto the co-defendant. But he didn't realize it until in the midst of trial. So, Your Honor, the answer to your question, sorry for the long-winded explanation, the answer to your question is no. Foregoing a defense is not a trial strategy. That is not a legitimate trial strategy. Moving to suppress statements that would assist my client.
Well, it doesn't make it illegitimate just because he was wrong, right? We make all kinds of tactical decisions that wind up hitting us in the face at trial, right? Or
Correct.
after jury
Correct.
deliberates.
But here is the antagonistic defense, this irreconcilable conflict that existed in this case that he should have moved to sever. First and foremost, he should have never moved to suppress statements that would have helped, that would have assisted in a defense of his own client. Secondly, he should have, even if he did not join in that motion, Your Honor, and the statements were suppressed, he should have then moved to sever so that he could have 2 separate trials where he could admit these statements without any prejudice to his co-defendant, and he could have argued, I didn't possess the gun, someone else did.
But again, the rub is really, at least from counsel's point of view, is what the videos showed, and counsel presumably made a strategic decision based on what he believed the videos maybe showed in making those decisions, no?
And, Your Honor, just to be clear, there are no videos that show him possessing a gun. It just doesn't exist.
It's not
By
clear
their
what he
statements.
It's not clear what he was retrieving from his desk and sticking in his waistband.
Yes, and Judge, let me quote their closing arguments. Pages 515 through 517 of the record. I submit to you, this is argument, I submit to you, he put something in the back of his waistband. They never claimed at trial that it was definitively a gun in the video. And you won't see a gun, my client possessing a gun.
Okay. Thank you, counsel.
Good afternoon, and may it please the court. Jennifer Watson for the office of Darcel D. Clark. The people respectfully request that this court affirm the judgment of the Bronx County Supreme Court.
Can you start with the video?
The video, yes, Your Honor.
Did he show a gun being put to his waist or not?
Your Honor, the video showed the defendant retrieving an item that definitely appears to be a handgun from under the table in his office and putting it into his waistband. Jay stated at the 440 hearing that he had reviewed the discovery in this case, including the video evidence. He formulated his strategy based on his belief that the video depicted his client, defendant, retrieving a gun from that office and putting it into his waistband. Jay's strategy had to presume that this video would be shown at trial. The prosecutor's arguments on summation, long after this evidence was adduced, are frankly irrelevant to that. The hearing court in this case...
Well, but why would they be irrelevant if even the prosecutor characterized it as something in he's retrieving something from the desk and putting it in his... That could have been a pencil, could have been a cell phone.
Your Honor, the prosecutor not only showed the video to the jury during this trial, but he blew up stills from that sequence of events that certainly arguably depict what appears to be a handgun. The prosecutor may have been being careful to say that the video was not precisely clear, it was not zoomed in on the object, but the object certainly appears to be a handgun in that video. And in this case, the court ordered a 440 hearing. The court took testimony from both attorneys, Ben and Jay, and issued a full and detailed written decision with findings of facts and conclusions of law. The hearing court concluded that Ben and Jay were not financially intertwined, as the defendants alleged, that they did not operate as a single entity, and that their familial relationship did not affect their representation. And this court has repeatedly emphasized that great deference is due to the 440 court's credibility determinations. Defendant failed to adduce any evidence at the hearing contradicting Ben and Jay's testimony. Defendant bore the burden of proof. He could have put in other witnesses, documents, materials, but all he entered in was the retainer agreement and payment record, which in fact corroborated Jay's testimony that he had no financial incentive to ensure that the defendants were tried jointly. Frazier's attorney subpoenaed various records from Ben Heinrich and didn't put anything from that into evidence at the hearing. To briefly address the two issues that defendant relies on to argue that a conflict operated on the defense, Jay explained that he considered the possibility of severance, but he ultimately concluded it was not in defendant's best interest for two reasons. First, because of the video, as discussed. He believed that would leave defendant exposed at a sole trial. However, he also believed that defendant's comparatively minor role in the gang assault would be clearer at a joint trial. With respect to Frazier's suppressed statements, defendant is flatly wrong to suggest that he joined in the motion to suppress those statements. He, in fact, merely adopted some of Ben's arguments with respect to the warrantless entry into tri-state, the warrantless entry which resulted in discovery of both the guns and the surveillance video, providing evidence of guilt of both clients. With respect to Frazier's statements, Jay believed those were better left out of the trial. He testified that he believed that more evidence of guns at tri-state would be bad for defendant because the video showed him holding a gun, and he and Frazier, his co-defendant, were business partners, close friends, brothers-in-law, and charged with acting in concert as to all...
But it was Frazier who made the actual threats, right?
Yes, Your Honor. Frazier, during the assault, threatened the witnesses with to shoot them. That is correct.
Okay.
those statements threatening the witnesses were part of the res gestae and would have been admissible against both defendants, even had the trials been severed. The court heard all of this testimony from Jay, credited the testimony, and concluded that Jay's decisions with respect to the severance and Frazier's statements were, quote, independent strategic decisions, not ones based on familial or financial loyalty. And for those reasons, the people respectfully request that this court affirm.
Thank you.
Your Honors, here's why I do not believe that trial counsel ever considered a motion for severance. In the middle of trial, and I alluded to this before at Your Honor's question, he had an epiphany. He said to the trial court, and you'll find this at page 332 of the trial transcript and at page 27 of my brief. He argued in the middle of trial that these statements, I own the gun holster, the ammunition, the vest, that these statements should be admitted, and the fact that they were not being admitted was prejudicial to his client. He said, the statements that were suppressed are suppressed only to Damian Frazier, but not as to my client. I think that is an expression of a fundamental misunderstanding of what suppression means, one. Two, he understood at some point that these statements needed to be admitted to deflect guilt from his client, to provide a defense from his client. That is why I do not believe he ever considered severance. Because if he had considered severance, he would have weighed the balance of admitting those statements and having a separate trial and showing to the court that his client had a defense to deflect guilt onto someone else. Secondly, Your Honor, at that conversation, this was a conversation on the record but outside the presence of the jury, the court became aware of a conflict, and no Gomberg hearing was ever held. Now, I wanted to make clear, during the 440 hearing, we spent...
What was the, I'm sorry, go ahead.
I thought the court found no conflict.
Oh, I'm sorry, Your Honor?
I thought the court found no conflict.
There was a conflict. I'm arguing there was. I know what the 440 court said.
What is the basis of your argument?
The basis of my argument is that my client
Go ahead.
my client had a defense, and his attorney...
But the defense was only as to criminal possession of a weapon.
Correct.
That defense does not do anything for you on the assault charge or the gang assault charge.
And
that is not a defense to those charges.
yes, correct, Your Honor.
So
Correct.
it's not, you kept on arguing throughout your argument that this lawyer waived his entire defense. But it wasn't an entire defense. It was only a defense as to the weapons charge.
As to 3 weapons, which constituted a substantial part of his sentence, Your Honor. So that's a big deal. That was a big deal.
Was he sentenced consecutively or concurrently?
Consecutively. He received a total of 12 years on the gang assault, and he was convicted of possessing all 3 guns, Your Honor, the .357, the .22, and the 9mm.
Okay.
Your Honor.
Thank you, counsel.
Oh, all right. Thank you, Your Honor.
Thank you both. FX funding. FX funding versus Fox RX. What is going on today? Do you know where your opponent is? Your adversary?
No, Your Honor.
Yeah, it's interesting.
The answer
Tell me who you are.
Good afternoon, my name is Harriet Fox.
well, he's the one that's late.
Yeah, can you come? Thank you.
He's the one that's running late.
Huh?
He's the one that's running late.
I see. I thought that was a different,
Isn't it FX?
yeah, it's a different one. Why don't we just mark them submitted? That's it. Your adversary is not here yet. Do you wish to argue? You for the appellant for FX funding?
No, Your Honor. I am the attorney of record for the defendant's respondents.
Okay, for Fox RX. Tell me what you want to do. Do you want to argue or do you want to submit?
Well, if there's going to be no argument, then I'd like to submit, but
Okay, so I'll mark it submitted.
thank you very much, Your Honor.
Thank you.
Sorry.
I could hear you fine.
Okay, next case on the calendar is Star Indemnity versus Corcoran.
I'll say it for you. Calling me a bitch. Okay.
Okay, this is Star Indemnity, right?
Yes, Your Honor.
Okay. Go ahead, counsel.
Thank you, Your Honor. May it please the court. This is plaintiff appellant Starr's appeal of the trial court's grant of summary judgment to the defendant listing real estate broker in connection with a massive freeze-up and flood at the Alexander condominium.
Did Corcoran have a duty, contractual or otherwise, to maintain the premises?
There is no contractual duty, Your Honor. Our claim is based.
Yeah. I apologize.
Our claim is premised on Espinel. That is, setting loose a force of harm.
So how in this case did Corcoran, who left the premises in January sometime, how did they unleash the force of harm that caused the damage, the ultimate
It is
damage?
our contention, Your Honor, that on January 7, the listing real estate broker, Sarah Fearon, during the course of her inspection of the premises, switched the thermostat off.
And how do you show that, other than making the statement? What proof would indicate that there's an issue of fact as to that?
We have an email from Ms. Fearon in the immediate aftermath of that January 7th inspection stating that there is an air conditioning problem.
That was for another unit, not the unit in question.
That is correct, Your Honor.
So what does that have to do with this apartment?
Because during her deposition, Ms. Fearon also testified that she knew that there was no problem with the HVAC system in 19D, which is the unit in question. Question then becomes, which she could not explain, how she had that knowledge without operating the thermostat. In addition, Your Honor.
So generally, when thermostats are turned off, it gets cold, you would agree?
I'm sorry, Your Honor?
When thermostats are turned off, it'll get cold?
That is correct.
Were there any complaints, was there any suggestion by any of the subsequent brokers or prospective people looking to rent the apartment that in fact the heat's not working, it's cold?
There are no reports alleged.
Well, any evidence in the record, forget reports, any evidence?
Well, Your Honor, we do have photographs that depict on February 17th, ice in the premises. This is an unoccupied apartment.
Yes, but the apartment was shown several times, no?
That is correct. And that is also one of our other contentions against the defendant Corcoran, is that they allowed, contrary to professional standards, as set forth in our experts.
But that's what Judge Acosta asked you originally. What's the duty? And I thought your answer was that essentially you're just making an Espinal claim.
I'm sorry, Your Honor, I could not hear.
Didn't you just say a few minutes earlier that your only claim here is under Espinal? Because Judge Acosta asked you what duty is owed by Corcoran under these circumstances.
Yes, Your Honor, and in each instance, Corcoran, through Sarah Fearon, instructed the desk to permit these prospective lessees to access the premises.
But wasn't
So by doing that, Your Honor.
Counsel, the owner of this unit here chose, instead of having an exclusive agent to show this apartment to have as many brokers as possible to market and show this apartment in an attempt to sell, right?
That's not correct, Your Honor.
That's not correct?
the-
Corcoran had an exclusive right to show and sell this apartment by themselves?
Corcoran was the exclusive listing agent pursuant to the contract that's part of the record.
Okay. Are you saying that, the way I read this record, there were other brokers who were invited to show?
There were,
That's incorrect?
there were other, the premises was advertised by Corcoran, who allowed prospective lessees and brokers to access the premises.
So in other words, it's your contention, sir, that let's assume someone else turned off the heat or left the door open. Corcoran could be held liable for the conduct of other brokers?
Yes, Your Honor.
And is
What
it,
is your authority for that?
Because under Espinal, they are setting loose by giving permission, by instructing the desk person to let people in, they are setting loose the force of...
is there a case under Espinal that would support such a tangential connection? Because I'm not aware of any case that says that.
There's no case with this specific point, but certainly by telling the desk clerk to allow people to access the premises, they are the ones.
But isn't that what they were responsible for doing? Just letting people consistent with the owner of the units showing of the apartment to go ahead and let people in?
Your Honor, as set forth in our expert's report, pursuant to professional practice,
Is there something in the contract between the owner of this unit and Cochran which required Cochran to accompany any other broker who showed this unit?
nothing specifically,
So there was no duty under the contract and nothing that would prevent Cochran from allowing another licensed broker to bring their client in to look at the apartment. Nothing in the agreement prohibited that, correct?
the duty is,
Counsel, answer my question. Is there anything in the contract that prohibited Cochran from allowing another duly licensed broker to show the unit to their clients?
there is nothing specifically in the contract, Your Honor. However, Espinal imposes the duty.
Thank you, counsel.
Thank you, Your Honor.
May it please the court, Glenn Kaminsky with the firm Omni Demers McManus, counsel for the respondents. I'm here today respectfully asking this court to affirm the decision of the Supreme Court. Plaintiff claims that the defendants somehow launched an instrument of harm by leaving the balcony door open and...
Well, actually, that's not their claim. That's just part of their claim. Their claim is even more basic. The fact of allowing other brokers to go in is sufficient to unleash the harm. Is that a fair reading of Espinal?
I do not believe so, Your Honor. Truly, I'm almost stunned as to how to address that, where there is a contract that doesn't require us to be the only agent to show the apartment, that doesn't require us to walk through the apartment with them. In the testimony of these real estate brokers is that is not what they do.
Your contract required you to coordinate the other brokers who would show the listing to their clients.
And which is what Sarah Farron did by keeping that list, by having the front desk let these people into the apartment. And so it seems to me essentially what the argument is being made against us is, with accord with H.R. Mock, that we failed to be an instrument of good.
How is this case different from the Stimmel case?
I think this case is significantly different than Stimmel. Stimmel, if you let me turn to it real quick, is interesting, and I think it actually highlights why summary judgment was appropriate here. In Stimmel, there was the testimony that real estate broker would, in her ordinary duties, draw those drapes. right, that had the cord that caused her to fall. Here, the facts are exactly the opposite. They said, we wouldn't normally look at the heat. I didn't look at the thermostat.
Right.
The balcony door was closed. Everything is actually in opposite. So when in Stimmel, an accident happened the same day, by the way, that they were showing, not 40 days later, where that real estate broker couldn't say, oh, I don't remember how I handled the drape that day.
But she admitted, basically she admitted to the underlying
created-
conduct. The
she
question
created
is
the issue
whether
of
that
fact.
conduct
100%, Your Honor.
unleashes an instrument of harm. Here, we have a question as to what actually happened. And we're not even at Espinal, we're sort of pre-Espinal.
I can understand that, yeah. I see that we almost basically never get there. And I don't think Wanaka does anything to enhance this argument at all, and unless this court has any
Yeah,
questions.
no, I
we'll
think
rest
we're
it.
good. Thank you, counsel.
Thank you, Your Honor.
Thank you. This case is exactly like Stimmel. The way
Tell
it is
me how.
The way it is exactly like Stimmel is that in Stimmel, the moving party could not and did not state that they did not move the cord. In this case, exactly.
Well, in Stimmel, the real estate broker testified that it was her custom to open the drapes, right, before showing. And the drapes were open at the time the plaintiff tripped over the cord, right? So the conduct to which she admitted is a direct result of the accident. So here, we don't even know the underlying conduct that you want to attribute to the instrument of harm, which is why it's sort of like a pre-Espinal analysis.
Your Honor,
I don't understand it.
Your Honor, the conduct is that Sarah Fearon, first of all, acknowledged that she does, in fact, check HVAC operability on a case-by-case basis. That's in the record. Ms. Fearon also could not explain how she knew there was no problem with the HVAC system in 19D without operating it. We also know that she
Well, we
did
know she was in the apartment, so if it wasn't working, she would have felt it on that day. So those statements mean and prove nothing.
Your Honor, they are essential, and they prove, first of all, that Ms. Fearon, A, acknowledged that she does indeed check HVAC operability. Our expert also explains that as a practice, because a lack of a functioning HVAC system would not be a latent defect. That would be a patent defect for which a real estate broker has an obligation to check.
Thank you, counsel.
Thank you, Your Honor.
Thank you both. People versus Shaw.
Good afternoon, Your Honors. My name is Kerry Elgarten. I represent Appellant Keon Shaw. The trial court here should have set aside the verdict based on the newly discovered evidence. The prosecutor and the judge
Counsel,
both...
Was the motion made in writing?
Excuse me?
Was the motion to set aside?
Motion was not made in writing.
And is that a prerequisite in order to consider that application?
In this instance, since it was fully adjudicated, since the information that it was based on came directly from the prosecutor, the purpose of writing is to provide notice and so that the matter can be fully fleshed out. And here it really was fully fleshed out. And also the prosecutor never said anything about the absence of a writing here. the matter was discussed on 2 different days. It was previewed by the prosecutor the first day when she learned about it. And then it was brought up on the actual day of sentencing. So in essence, what was going on here is the claim is that the appellant tossed urine at a correction officer. And the lab test showed they could not find urine on the uniform, even though the uniform was
They
sent.
couldn't find urine on the little swatches they had cut out.
They had the entire shirt.
I understand, but they didn't test the whole shirt.
Right.
They cut swatches.
cut-
And so if they cut swatches from the wrong spot,
Why would they cut? They presumably
weren't
they're,
there.
they're experts and they do it. They cut it from the right spot. But regardless of whether this is dispositive as to whether or not it was urine, it certainly was a question as to whether it's not urine, since there's a lab test that could not, 2 lab tests, 2 different tests, swatches here, swatches there, that was unable to detect urine.
So, counsel, the record reflects, yes, 2 series of lab tests, but it
Speak up,
seems to
sir.
be, seems that, as my colleague indicated, the wrong areas were tested. What about the other indicia of urine, as in the smell that was testified to, the fact that it was liquid in the urinal, it was the right color, there was a threat by the defendant that he would use urine and throw it at
My argument is not that the evidence
You
is
really do have to wait till I finish, thank you. And how about the statement to Corrections Officer Hopkins that he was using his urinal?
Okay, so first of all, I'm not arguing that the evidence is insufficient. I'm arguing that Jolly's testimony was critical to the people's case, and that
And how was Jolly's testimony critical?
Jolly
Weren't
is the
there other
person-
witnesses?
Jolly is the person. So everything's on video that there's liquid tossed by Appellate. The only question is, what is in the bottle? The lab test was unable to detect any urine. Jolly testified, and the prosecutor emphasized it. She previewed in her opening, and she emphasized it in her closing statement.
Was Jolly, I'm sorry, counsel, was Jolly even present when the act occurred?
Jolly's the one, yes, Jolly's the one who said, I saw him urinate into the bottle. Like, you know, a little bit like saying that he
but
turned.
he wasn't present when the contents of the urinal were thrown on the officer.
Correct.
He wasn't there.
Correct.
Right?
But that's irrelevant to the, okay, sorry.
So that the testimony of the officer who was drenched in this liquid certainly testified about the smell, it fell on his face, et cetera, et cetera. Why is that not sufficient evidence?
I'm not saying it's not sufficient evidence.
No, but
I mean,
counsel,
in point 1, I do argue that
counsel,
the weight of the evidence.
right, you do argue it,
No,
right?
that it's against the weight of the evidence, yes, that the lab
No, but
test prevails over that. But the point I'm talking about now is the significance of Jolly's testimony and the impact of the newly discovered evidence, given what I maintain, and I think should be clear, is a close case. Absolutely. McNamara said, you know, I got hit by a liquid, that's no doubt. He said it smelled like urine. To say that Jolly's testimony was virtually irrelevant to the outcome here, that there wasn't a probability of a different outcome, when the prosecutor at the end is like, at the beginning, she's like, you're going to hear that Jolly said he urinated into that bottle. So what's the question? Of course it's urine. He urinated into that bottle. But if Jolly's credibility is attacked and is weak, that critical fact that they rely on no longer exists.
But you want to attack it on an unrelated, based on perjury in an unrelated case, right?
Correct.
Jolly's perjury.
Correct,
Okay.
yes.
Thank you, counsel.
Good afternoon, Your Honors. Malancha Chanda for the people. The standard for setting aside the verdict is that the evidence, the newly discovered evidence, must be of a nature that there's a probability it would have changed the verdict. Here, there is no such probability, and that's why the court was correct to deny the 330 motion. As your honors have pointed out, Jolly's testimony was merely corroborative and secondary. There was compelling and unimpeached evidence aside from the testimony of this officer, who was not even there at the scene of the crime, that established the contents of the urinal. Primarily, the victim himself said not only did when he walked into the room, did the contents were consistent with the color of urine, he was the one who was splashed with it. And then he felt it, the offensive smell of urine, which I don't think there's a doubt that everyone knows how offensive urine smells like. And then, of course, there was the other officers who saw the color of the contents, and also, I believe, Captain Bender, said that she heard the defendant say, "I'm going to throw piss at you." And then the video evidence should put to rest any doubt as to what the contents were. I think it's very clear, and I believe the court has hopefully viewed the video, that he was holding the contents of a urinal that was pretty much full all the way, not consistent with being filled with apple juice. He was using it in a threatening manner. He again said that, "I'm going to use this urinal, I'm going to throw this on you." So taking all that into account, the fact that Jolly, he didn't even see the actual urinal being filled from defendant's body. It was a reasonable inference, given the nature and the secondary.
So do I understand you to be arguing that even without Jolly's testimony,
Yes.
there was no reasonable
No probability at all.
probability that the verdict would have been different?
Absolutely. And I believe that's related to the weight point as well. And since my adversary has not brought up prosecutorial misconduct, I will not address that unless there are questions, and we will rest on our brief.
Okay.
Thank you very
Thank you,
much.
counsel.
The idea that Jolly's testimony wouldn't matter here is, I think.
But the question, Counselor, question is if we were to put aside Jolly's testimony, would there be sufficient testimony?
No, that's not the question. The question
not the question?
Sorry. The question is
That's a question in my mind.
whether there's a probability that without that testimony, we would have had a different verdict.
There was no, you mean no reasonable probability?
It actually says no probability is the way the statute.
Well, it's reasonable probability, the
Right.
way I read the
Right.
case. Since
So
you are contradicting the judge, I figure I'll do the same with you.
Okay. The idea that that testimony here was not relevant is basically saying the conclusion that we're reaching here, if we say that couldn't have, that there's no probability it would have affected the result, is that even though there was a lab test performed, 2 lab tests performed, I know there was just swatches and they can't test everything. 2 tests sent specifically to ascertain whether there was urine, and they both come up negative. And because one officer says that it was urine, we have to accept that officer's testimony. The reason that multiple officers are presented is so that the prosecution presents a whole case with different officers corroborating each other. And if one of them is shown to have lied recently at the grand jury by the district attorney's own point of view, it's totally undermining the prosecution's case. And it's ignoring the fact that it's acting as if automatically the testimony of one police officer does the trick. And just quickly, the appellant said that it was urine, and he explained he was trying to get them mad. He was mad. He knew they would be scared if there was urine in the bottle.
Thank you. Cha versus New York State Industrial Board. No quiero oírse hablar, no quiero oír a nadie, ¿está bien?
May it please the court, Saul Zabel on behalf of the appellant. Good afternoon.
Good afternoon, Mr. Bell.
We're dealing with a decision from an Industrial Board of Appeals court that has dispensed with all notions of admissible discovery. Although there is no formal discovery before the Industrial Board of Appeals, no formal rules of evidence before the Industrial Board of Appeals, there has to be some notions of evidence.
Well, what about the investigators' interview of 7 kitchen workers that were included as part of his recapitulation sheet, that those workers were owed about $127,000?
Those investigatory reports did not come in through the investigator. They did not come in through the interpreter who helped write them or translated them. They did not come in through the investigator's supervisor. They didn't even come in through the supervisor's supervisor. The Industrial Board of Appeals said, oh, it was in the Department of Labor's investigatory file, therefore it comes in. And that deprives Mr. Cha and Millennium Daedong the ability to question those people who took the statement and to take it a step further.
So are you suggesting, Counselor, that hearsay is not permitted in this kind of proceeding?
I'm sorry, I might have misheard, but if you're saying, am I saying that that's not permitted? What I'm saying is the Industrial Board of Appeals should have disregarded that evidence because it simply is not admissible under any standard.
Because it's hearsay, in other words.
It's triple hearsay.
Okay, so, but isn't hearsay admissible in administrative proceedings? I mean, there are reams of cases on it.
Yeah, and hearsay can be admissible. But the problem with that is we now take it a step further and compounded this travesty. We subpoenaed all of the alleged statement givers. We actually had them subpoenaed to come down. The Department of Labor did not bring them. The Department of Labor opposed our application for a subpoena, and notwithstanding the fact that they did all but only one of them appeared pursuant to subpoena and testified, that would be Mr. Bang.
But did you submit evidence that contradicted any of the statements in either the Kim's interview or anything else?
Not only did I submit it, but Mr. Frank King, the Department of Labor's investigator, said that the computations that were prepared by the Department of Labor don't match up to the statements that were taken. He acknowledged that if he was doing this investigation, A, he would have asked more questions and found out more information, but he said that the recapitulation sheets, the summaries, don't match the actual statements. There was no support. So even though...
Did you provide the time sheets?
No.
Yes. Yes, we did provide
When
the
did
time
you
sheets.
do that?
I'm sorry, pardon me?
When did you do that? Early on in the investigation?
No. Early on in the
In
investigation...
fact, you resisted it all along, right?
Well, I would like to say that I was involved in the process all along, but I wasn't. But there was an invitation. The notes indicated that there was an invitation for the Department of Labor to review and inspect those records at my client's attorney's office. At the hearing, those documents were provided.
I'm sorry. The Department of Labor had to go to the client's attorney's office when for years they had been asking for documentation from your client to no avail, not even the courtesy of a response. Not even the courtesy of a response.
As disappointed...
Quite frankly, I read your brief and was amused at your outrage of their delay when for years your client failed to respond, attorneys would get letters and nothing.
So in response to your question, yes, they have to go to my client's attorney's office to view those records. If they are being stored there as a matter of course. That's not what I say, that's the law. The documents, we're only obligated to make those documents available where they are being stored.
Timesheets was what they were asking for,
Yes.
right? Timesheets that did not conform to the statutory requirements, didn't say how much the salary was for, had no dates. I mean, the nature of those records were left a lot to be desired.
May I respond to that?
Please do.
Thank you. The administrative law judge said that, but if you look at those records that were attached, they indicate the days worked and the hours worked and who worked them. Those are the bare minimum requirements that are necessary, and not every...
I wouldn't call those timesheets, right? These are documents that were prepared after the fact. There was testimony that workers were asked to sign blank timesheets, okay? So the record here had plenty for the a hearing officer to consider with respect to the deficiencies of your client's submissions.
There is nothing in the record that indicates that these were created after the fact, and there simply is not enough by the hearing officer's own writings. There's not enough. It's not supported.
Were you asked and contacted directly by DOL to appear at a conference that the council failed to appear?
I don't think
It appears prior to my involvement in the case.
I understand
that occurred,
but,
yes.
You know, your client's counsel, previous counsel.
The records reflect that, but the records also reflect that there were no efforts to contact the attorney to view those records.
I thought that on March 2016, the Department of Labor contacted Mr. Shah directly and told him that his attorney had not provided any of the records that were promised to the Department of Labor.
At the time that that communication occurred, the Department of Labor should not have contacted Mr. Cha because they knew him to be represented by an attorney. The only admissible evidence indicates that the Department of Labor, despite knowing who his attorney was, refused to reach out to him. And the investigator who testified...
I thought they contacted him in March 2016, mid-2016, they tried to reach petitioner and the attorney, but they were non-cooperative, is what DOL says.
And here's the problem with that. The one DOL investigator who introduced that document could not verify that, and specifically said that that log sheet was clearly missing entries, had to be missing entries, and couldn't be relied upon. That's what Frank King, the Department of Labor investigator, said.
Okay, but in September of 2017, the attorney, I don't know whether it was you or prior attorney, got corresponding, in fact, an email from DOL advising your client and his attorney that you have not appeared and the matter will be referred for an order to comply, right?
I agree with that, and I'm sorry, I know I'm treading on...
No, I control the clock, don't worry.
Thank you. That's correct. But regardless, the administrative law judge said, I'm not going to address whether there's a recalcitrance issue with reviewing those records. You can bring those records here now. This is a trial de novo. The problem was she relied on the summary from an investigator that was not there, from witnesses that refused to come in and testify, rather than looking at...
Well, you raised that issue, Counselor, that you subpoenaed the witnesses that didn't come. Did you attempt to enforce the subpoenas?
Well, that's another problem with the system. We did not attempt to enforce the subpoenas because they just came back returnable then. But enforcing those subpoenas before an administrative tribunal is a fool's errand. We've done it before where we've had state Supreme Court judges saying, okay, we're ordering them to come in this second time, and if they don't come in, then we will issue an order of preclusion, precluding, whether it's the Industrial Board of Appeals, Wage and Hour, or the State Division of Human Rights, from considering any testimony on their behalf. The problem is, the Appellate Division says you can't do that. A state Supreme Court judge cannot direct a state agency. So it's a fool's errand. There is no legitimate basis for contesting a failure to appear.
Thank you, Counsel.
Thank you, Your Honor.
Appear.
It's everybody's fault.
Appear.
Good afternoon. May it please the court. My name is Jeremy Fetch. I appear on behalf of the New York State Attorney General's Office for the respondents, the New York State Industrial Board of Appeals, the New York State Commissioner of Labor, and the New York State Department of Labor. Thank you, Your Honors. I would ask that Your Honors affirm the Respondent Board's decision. The Board's decision rested on substantial evidence. The penalties here also...
So substantial evidence is the standard that we are applying here, correct?
Yes, Your Honor.
Counsel.
Yes, Your Honor.
So substantial evidence, pretty low standard, right?
It is.
Point to any evidence in the record that indicates that the workers were owed the money that you said they were owed.
So in this situation where the petitioner, as Your Honors rightly noted, from the time of the visit by Investigator Kim on February 23rd, 2015, all the way through the order to comply and finally the hearing in June 2019, the petitioner's records were unavailable and not given to DOL. In that case, it's standard practice under the labor law, under the precedents, under 196A, the employer, when there are no records from the employer, the Department of Labor has to come forward with the best reasonable approximation of the wages that are owed. They did that based on the interview sheets.
So, your adversary argues that Kim obviously didn't testify.
It's true.
That those sheets should not have been admitted because it's double or triple hearsay. Now, isn't there some legitimacy to that argument?
Your Honor is correct. Obviously, if this was a trial in front of a judge and in front of a jury and a trial court, some of this would be inadmissible hearsay. But the fact is, I'm not here to try to overturn, centuries of precedent in the State Administrative Procedure Act and the hearsay rule. This is known to both petitioners and everyone else available. This evidence is gathered and kept in the DOL.
So rather, is it an issue of weight and how much weight should be given to the investigative notes versus the timesheets that were established, that were put into evidence?
Yes, I think you can look at it in terms of weight as opposed to admissibility. And in some sense, the underpayment calculation was based on these interview sheets. It was based on the claim forms. What Frank King testified to was that the narrative report was not the basis for the underpayment calculation, that in fact the narrative report was demonstrated the methodology that was used to compile the underpayment calculation. So to some extent, Your Honor is right to point out that some of the evidence in front of the board was thin. But what you're confronted with is, on the other side, the petitioners, as Your Honor's rightly noted, refused to come forward ever with any evidence. And when they finally did come forward, their evidence was so clearly didn't reach the standard laid out under the labor law for what's required for wages.
So why weren't the timesheets sufficient here? My colleague pointed to some of the issues with them. Why weren't they sufficient?
So with the timesheets that, I assume you're talking about the petitioner's timesheets? The timesheets petitioners brought in seemed to clearly fit the workers' hours never to rise above 40 hours per week. No matter whether a worker works 5 days, 4 days, 6 days, what Your Honor should look at is in the exhibits of the timesheets at the end of the day. Usually, no matter what hours what days the worker works during the week, those days always end on either, an exact half hour or exact hour, and they're manipulated throughout the week such that it's almost like someone's trying to fill a certain number of glasses of water and always keeping it in the exact same point. So they just add water or add glasses to make sure that it never spills over.
Counsel, what about the pay stubs?
I'm sorry?
What about the pay stubs that pertain to Mr. Bang? Those were issued by the employer, right?
Yes, well, that's an interesting issue, Your Honor, because Mr. Bang, who did come to the hearing, and by the way, he also and John Seo both came to the compliance conference in December 1st of 2015 that petitioners failed to show up for, Bang brought his pay stubs. Petitioners didn't bring his pay stubs. Petitioners presumably issued those pay stubs, so even at the hearing where they brought their other false records, they didn't even bring the records for Bang, who they've known from the beginning was the person who brought this case and who did testify at the hearing. And just briefly on the point of the subpoenas, the proper way for the petitioner to get the claimants to come, as Your Honor noted, is to enforce the subpoena. That's enforceable under the CPLR. They didn't do that. They didn't ask for an adjournment of the hearing so they could try to get compliance. They didn't make any efforts to enforce the subpoenas. And then they turned around and tried to get all of those claimants' claims dismissed at the hearing, which is contrary to prior law.
Thank you, counsel.
Thank you.
I'd like to point out that Mr. Bang was called as a witness for Mr. Cha, and those records came in while we were questioning his payroll records. Mr. Bang testified that there were times that he would only work one day and his paycheck would indicate $120, and he acknowledged that that meant a day. But he thought he was entitled to overtime for any hours worked over 8 in a day, not based upon 40 in a week, and that was his testimony. Now, I'd like to move on to the imposition of the 16% interest, the compounding of that interest, and a 200% penalty that's been assessed over and above the 100% penalty that's included as liquidated damages. That is a violation of my client's rights that so far exceeds what any $5,000 or $6,000 penalty could be assessed under the law, that it is shocking to the conscience.
Is the 16% interest statutory? I believe it.
It is.
That would be the top of the range, right?
It is. That is absolutely correct.
And you have
That's unlawful.
You have a problem with the range, or you have a problem with the imposition of the interest?
Both. I have a problem with both. 16% was the interest rate that was set by our legislator when interest was somewhere.
Do you think that an Article 78 is the proper means to challenge the constitutionality of that statute providing for 16% interest?
In the context of this case, yes, I'm asking this court to acknowledge that that 16%, when interest is now at 0.5%, at the time we filed this was at 0.25%, is constitutionally inappropriate. It is a violation of my client's rights. That compounded with the compound interest of interest on interest on interest, by the time this case is decided, there'll be more owed in interest than the Industrial Board of Appeals thinks is owed my client.
Wasn't a lot of the delay attributable to your client?
No, it is not. The delay, and if you look at the log that was somehow allowed into the Industrial Board of Appeals, shows that this case sat dormant for years without them doing anything to it.
You would agree that you didn't show, not you, of course, but Mr. Cha did not show up at the compliance hearing, didn't submit documentation, and so on and so forth. So it's hardly the situation where Mr. Cha has no culpability in the delay.
That's missing one hearing date. One hearing date.
No, come on, counsel, please.
According to the log.
From 2015.
You finally showed up in 2019 after refusing to turn over records for at least a couple of years. Please, stop misrepresenting.
I have to dispute that he refused to turn over records when he said that he made those records available, and the Industrial Board of Appeals, which is the decision we're deciding on here, refused to decide that issue.
Okay.
He said it's a non-issue.
Okay, thank you, counsel.
Thank you very much for your time and your courtesies.
MTA?
Okay. John Nikolich, representing MTA and New York City Transit Authority. We're seeking a stay of an arbitration of various construction claims in a statement of claim that was filed by Westfield. And those claims arise from a lease concerning the MTA's redevelopment of the Fulton Center Transportation Complex.
Are there any provisions in the lease which clearly and unmistakably state that arbitrability is for the arbitrator?
No, no. In fact, the court below
The
found that it's
Supreme
for the
Court then was correct that Westfield's claims come within the scope of the arbitration provision that's contained in the lease.
No.
Tell me why not.
No, because Westfield has relied on one particular provision, say, in its statement of claim, makes one conclusory statement saying that the claims relate to failure to provide the premises in tenant-ready condition. One conclusory claim. Then they set out 11 different work items, and none of those work items allege a failure to meet the requirements for tenant-ready condition. Tenant-ready condition is very specifically defined in this lease as compliance with what is called the commercial usage area plans and elevations, which are construction drawings for this Fulton Center. And they never allege that MTA failed to provide something shown in those drawings. Just to give an example.
Counselor, can we take a step back? Because I guess I'm having some problems following your argument. My understanding is what the claim is, that these fall within the substantial final completion condition. So that's the question. Do these areas of controversy fall within what I just said?
We say they do not.
Okay, and I accept that. That's a fair argument to make. But doesn't the lease, specifically section 3.1, say with respect to those issues, whether or not it falls within substantial final completion shall be resolved by the arbitrator?
Yes.
So hear me out. So therefore, with respect to these disputes, maybe you're right on some of them, that they fall within this category, or maybe they don't. But it seems to me that the lease lays out a basis as to how that's to be decided by the arbitrator, as my colleague was suggesting.
No, because Justice Cohen below said that to determine whether it was arbitrable was for the court to determine.
Under section 23.1, it says, if an arbitrable dispute is construction related, the arbitration shall be administered under the construction industry arbitration rules and mediation procedures of the AAA, which say that that issue is decided by the arbitrator.
No. So number one, you said if it's an arbitrable dispute. So first you have to determine whether it's an arbitrable dispute.
In construction related. Don't leave out the other part, okay? Because you have to read them together.
Yes, you have to read it together.
So what the claims here are, as my colleague has just said, they were issues concerning substantial completion or final completion, right?
That's not what the statement of claim says, but the statement of claim refers to tenant-ready condition, which is one of the components of substantial completion and final completion.
Okay. So if it falls as one of the components of that, then that would be a controversy that is to be arbitrated.
That's correct. If Westfield had alleged facts showing that it comes within those parameters.
I'm sorry for interrupting, but isn't that what you're going to be discussing before the arbitrator, that there are no facts alleged, therefore this doesn't fall within the final completion or substantial completion, and therefore that claim shouldn't be arbitrated? All we're deciding is, do we decide these issues as a court, or should the arbitrator decide those issues?
So we submit that the court should do it, as Justice Cohen actually said, but what he did not do was look at each of the 11 claims to determine whether the facts alleged for each claim brought it in the parameters of an arbitrable dispute. Just to give you one example.
But are we rewriting the lease? If we accept that position, wouldn't we be rewriting the lease? Because section 3.1 seems to say that it's for the arbitrator to decide.
No, it's not for the arbitrator to decide whether it's arbitrable. Once it's determined to be arbitrable, the arbitrator then decides it on the merits, okay? So to give one example, this bathroom issue. They say, we didn't provide bathrooms. The thing is, for tenant-ready condition, you have to satisfy the commercial usage area plans and elevations. There's no allegation that those bathrooms were shown on those commercial usage area plans and that MTA was supposed to provide them. They're not there. There's no question about that. So they cannot allege that we were required to put those bathrooms in to meet
Counsel, I
tenant-ready
honestly,
condition.
Counsel, I honestly think that you're arguing against yourself because the lease clause speaks for itself, doesn't it?
I agree the lease clause, and we're trying to enforce the lease clause.
Okay, thank you, counsel.
May it please the court, Harris Kogan, a blank Rome for the respondent, Westfield Fulton Center. The IAS court, Justice Joel Cohn, properly looked at the claims and said that the claims all implicated and raised issues of whether there was substantial completion or final completion. He said that is his duty to do. He looked at it and he said, now it is for the arbitrator to have a factual hearing and determine whether or not that in fact has been met. That is the law, that was the lease. The absurdity, and I don't like to use that word, of the position that's being advanced by the MTA. I'll give you an example. They say that one of our claims is that the MTA failed to put in a 14.5-inch concrete slab to level with the street. And they say, well, Justice Joel Cohn should have looked at the hundreds of pages of construction plans, and he would have seen that there is some statement in there which talks about how the tenant must finish the floor. And he says, open and shut, it's not arbitrable. Now, finish the floor means you put tile and you put carpet. I use that as an example. The role of the court in determining arbitrability is not to make a full factual hearing as to who's right or who's wrong. The role of the court in determining arbitrability is to see whether the claims do implicate issues of substantial completion or final completion. And each of the claims that we raised, including the bathroom issue. The bathroom issue is a perfect example because what happened with the bathrooms is the lease provides and lists 24 food establishments if to be in this mall, but the MTA failed to provide employee restrooms as required by the health code. Fast food service employees have to have restrooms. And that is an example of lack of substantial or final completion and lack of tenant-ready condition. And that's for the arbitrator to hear facts about, which has happened. We've had 8 days of arbitration hearings. And the factual issues, again, is for the court. So what Justice Cohn did in his decision was perfectly appropriate. He said, on its face, the claims all raise issues of substantial or final completion, which are arbitrable. Let the arbitrator hear the evidence and determine whether, in fact, those claims are read. It's not for the court to do a full factual review in the guise of arbitrability. Thank you.
Thank you, counsel. I'll give you the rest of respondents' time.
Yes, briefly, Your Honors. The case law that we've cited is very clear that the court is determined whether the claims as alleged in the arbitration, and that's in Westfield's statement and claim, are claims that are arbitrable. So on these employee restrooms, not only is there tenant-ready condition, the landlord's work was defined to be doing the core and shell-based building improvements. That's never alleged in their statement of claim that these bathrooms was a requirement shown under those plans and specifications.
Counsel, the problem that you have is that you seem to want to have a hearing within a hearing, right? So have the Supreme Court do a hearing in order to determine that the actual full-fledged hearing has to go to the arbitrator. That doesn't make any sense and certainly would not fit with judicial economy.
But that's not what we're asking.
It seems to be.
We're asking the court just to look straight at the statement of claim, not to go out.
What we have to look at is the agreement. And the agreement says that anything that falls under 3.1 has to be arbitrated.
No.
And I haven't heard anything from you why the items claimed do not fall within 3.1. They accepted this premises from MTA without it being complete on a good faith basis that you would come back and you would finish the job. And now we are here because MTA did not.
There are a lot of factual issues there that would be determined either in the arbitration or, if it were not arbitrable, in a court of law. So we respectfully disagree, Your Honor.
Thank you, counsel. Ay, Dios mío.
Mamma mia.
Tishman? Okay.
I think so.
May it please the court, Old Republic is seeking to overturn the multiple decisions made by the Supreme Court for the two main reasons.
Tell me who you are and who you represent.
I represent Old Republic, the appellant. My name is Kate McGuire-Tedrick, and we are seeking to overturn those decisions based on the fact that the anti-subrogation doctrine bars the claims made herein, and the actual injuries underlying do not arise out of the use of a vehicle.
So tell me, counsel, did the fall here arise out of, I think you're getting to it, arise from from the inherent nature of the vehicle, or did the vehicle in some manner produce the injury?
Absolutely not on both counts. Here we have a undisputed set of facts that the individual was finished with the loading and unloading process. It was complete.
Well, that's contested. That is contested as to whether or not the loading process was completed.
Well, as the plaintiff, who's the only witness, testified, he was complete, and he testified that way multiple times throughout the deposition.
Well,
I understand that
there are issues with respect to that, but does that matter, I guess is the question.
Well, at the very least, then that's an issue of fact, and therefore there should not have been a decision finding that it arose out of the loading and unloading. But other than that, we have an individual that fell within a hole that was uncovered, that was 100 feet away from the vehicle, that had nothing to do with the vehicle itself. Instead, this case is much more similar to those such as Cosmopolitan Mutual Insurance.
But use is defined as loading and unloading, right?
There was no unloading or loading happening at the time.
That's not the question. I just want to make sure that we're clear that that's how use is defined, which goes to the question that Justice Singh asked, whether he had completed it or not.
Yes, had he been unloading prior to the accident? Unquestioned, yes, he had been unloading, but it was complete at the time. There are several cases within New York State that have found that where a defect in the property is the cause of the injury, it is not arising out of the use of a vehicle. For example, we have one case, which I was mentioned, Cosmopolitan Mutual, where they found a defect in the flooring after they stepped out of the vehicle. Therefore, it didn't arise out of the use of an auto. We also had another case recently in 2022, I believe, where tripping on gravel at the property did not arise out of the use of a vehicle, even though the person was in the middle of unloading, okay? And so the concept there, and the courts had determined that if any passerby could have fallen and hurt themselves because of this incident, because of the location and the nexus of the event, then it doesn't have anything to do with the use of a vehicle or the completed operations doctrine. Based on that fact,
Not only was Tishman Riverside not entitled to summary judgment here, but also Port Morris, who is an insured under the policy provided by the insurance company of the state of Pennsylvania. I'm going to call it ICSOP to make it quicker. ICSOP has a wrap policy of which Port Morris is an insured, just like Tishman and Riverside. Tishman and Riverside are currently getting a defense from ICSOP under that policy. Okay? ICSOP was tendered to by Port Morris in 2018, and ICSOP never responded. They never denied coverage, they never granted coverage. And then we brought this action, this third-party action, bringing them in after there was a dispute as to whether or not the original action is being brought in the name of Tishman and Riverside and actually is being brought up by ICSOP. We brought them in, and we're saying, you owe defense costs for our mutual insured Port Morris because your policy provides coverage. Now, because they failed to provide a denial of coverage, they are precluded from relying on their exclusions. The exclusion that they want to rely on is the auto exclusion. Now, as I already argued, it didn't arise out of an auto. But even if you look at their exclusion itself, which isn't applicable because they failed to provide a denial, their exclusion is loading property. It's not disputed. No one was handling property at the time. So even their own exclusion doesn't provide a lack of coverage for Port Morris. So based on this fact, at the very least, Old Republic should be able to maintain an action against ICSOP, and it was improperly denied at the motion to dismiss stage. Thank you, Your Honors.
Good afternoon, may it please the court. Gregory Dennison, Sabre LLC for plaintiff respondents Tishman and Riverside. The issue of whether or not the vehicle was in use, I think, is a clear one. The Court of Appeals in Wagman adopted the completed operations test, which does not have a sort of mechanistic, the moment the last piece of material leaves the cargo bed, the loading and unloading is completed. Rather, the language reads, the sounder...
So we've had a lot of case law since 1952.
Agreed. But it's not been, but it remains good law, and the critical language here is to cover the entire operation of making the commercial pickup and delivery. In this instance, what happened is the vehicle enters the loading dock. It has to go through some wind flaps and a plastic sheeting of some sort. The vehicle backs up to the loading dock, and the vehicle is unloaded.
Counselor, we're familiar with facts.
Yes.
I guess the question I have for you is how has it been shown here that the injury is the result of an act or omission related to the use of a vehicle? Because
Certainly.
the injury is a condition on the premises.
Correct.
Nothing to do with the loading and unloading of the truck. So aren't we missing a step here?
No, we're not. When the vehicle is completed the unloading process, the driver then exits the loading area. He has to go through, I believe, the bay next to the one he entered through in order to allow it to essentially open the bay. There's some sheeting there that is tied up that he cannot drive through without removing it or releasing it in some fashion.
So at what point do you think use stops? I mean, let's say that it comes in with a truck is unloaded, driver goes to the 4th floor to the bathroom.
Yes, that is unrelated to the...
And then falls in the bathroom because there's some defect in the bathroom.
I would agree with Your Honor at that point that is not part of the use of the vehicle. But the vehicle cannot exit the loading dock until this process is completed. This is a necessary step for him to leave the loading dock area. He's not traversing where pedestrians would otherwise...
Did he open it to get in?
I believe that it was...
Did he pull those sheets and tie them off to get in? I don't remember reading anything about that in the record.
I don't believe he testified to that. I'm not aware of that, but in order to leave, maybe he could back in, but he couldn't go the other way. I'm not really clear on that, Your Honor, but he did.
Why? The plastic sheeting only moves in one direction?
There's two things, and I don't know whether somebody else perhaps may have, there's a plastic sheet and then there are wind flaps. He only testified, I believe, to the wind flaps, but he said to leave, he had to untie the plastic sheet because it was fastened in some fashion. I honestly, candidly, Your Honor, I don't know. I don't believe he testified to that. And he's not testified in the DJ action that we are a part of. But he testified he could not, his vehicle was trapped.
That's all well and fine. The problem you have is he doesn't get injured because he trips on the wind flap.
No.
He doesn't get injured because somehow the plastic hits him.
Correct.
He gets injured because there's a hole in the ground.
Correct.
With a cover that is not fastened, and therefore the premises is not safe.
Correct. Those are the allegations. Those are the allegations. But
Is there anything in the record that refutes those allegations? I saw nothing from your side that says there was no hole in the ground.
no, I don't believe.
Or that it was sealed. I saw nothing like that. So there's no question that the man fell in a hole.
Correct.
Right?
I don't dispute that he fell in a
And
hole.
the hole had nothing to do with his loading or his unloading. Nothing.
The hole was presumably there.
Absolutely. So we can agree on that. So whether he had to walk near the hole that he obviously didn't know about.
Well, Your Honor, if I may answer that question before, I know my time is up.
No, go ahead.
Okay, thank you. You're looking for some causal connection, correct, between the loading of the vehicle and the fall?
I'm looking to how does his walking around the vehicle and falling in a hole, how that equals use of a vehicle.
Well, he was doing this to essentially open the gate so he could leave. I mean, in some fashion, he could not leave without going through exactly where he went through.
Again, if the gate hit him, you may have an argument.
That would be.
That's not what happened here.
But in doing this, there was some potential for some comparative negligence that would have tied this to the vehicle.
I'm sorry. I don't understand. How does that tie it to the vehicle?
The driver's actions, how the driver's actions.
Well, the driver falls in a hole, okay,
Correct.
that's the negligence. How is that connected to the vehicle?
Because he's the driver of the vehicle, he's doing this he's taking the step necessary to disembark.
That means that every situation, there would be liability, including the situation, the example.
So even when he's on the 4th floor, if he hasn't completed the unloading or the loading, and he's not ready to go, he could be in the cafeteria on the 10th floor and falls due to a banana that was dropped by another person in.
But that would be, that's not necessary for the vehicle to safely depart the loading area. He doesn't need to go to the cafeteria, the bathroom, go get a cup of coffee or anything like that. He does have to do exactly what he's doing.
But you started by citing a 1952 Court of Appeals case that defines completion, right, or defines use as the full, as the completion. So you argue,
right,
there has to be a complete operation of transporting the goods between the vehicle and the place from or to which they are being delivered.
Correct.
Citing Wegman, right?
Right, but the language there is not limited to the loading and unloading. It talks about the completed operations concept, but it says to cover the entire operation of making commercial pickups and deliveries. He could not complete this delivery until he's able to leave the loading area. That is what he's doing.
Except that the case law says if the injury happens having nothing to do with the actual delivery of items and is premised on a defect at the premises, as your adversary pointed out in the Cosmopolitan case, it is perfectly on point on this issue.
Well, Your Honor, I know my time is up, and I appreciate if I could have just a few seconds.
I'll give you
to
10 more seconds and we're done.
There's the Glynov case, the Stryker case, which is a district court case, but it was cited by this court in Zurich and countrywide, that you need only show that the accident relate to the acts or omissions related to the vehicle. Here, the vehicle cannot leave until this is done.
Okay, thank you.
Good afternoon, Your Honors. Elizabeth Allstrand for Accept, the insurance company of the state of Pennsylvania. Just to touch on one of your questions, Mr. Rodriguez did testify that to enter the loading bay, the sheet did have to be pulled across, and then it was pulled after his truck and tied either by another worker or
that's fine, but he didn't get hurt by the plastic.
He didn't, but I think the key piece
he
here.
Fell through a hole.
He did.
And there is nothing that you can argue about use of the vehicle to account for that.
I think there's two ways that this case is different from Cosmopolitan and different from some of the other cases that talk about other causes that are perhaps a little bit more remote from the vehicle. One is that this was part of the continuous act of the use of the vehicle and the delivery process. So the example that you gave about going to the
How is falling in a hole part of the continuous act of unloading the vehicle?
because he had to go undo the flap to get out. He could not complete his delivery. He could not complete his job. He could not get to the end of the operation.
How is falling into an unguarded hole integral to that process?
Well, I think that Countrywide and Zurich indicate that just because there is another cause does not take it completely out of the exclusion. I mean, arising
Another
out
cause.
of is extremely
That's
broad.
the only cause. The only cause of his injury is falling in the hole. It's not. They're not two proximate causes. There's one proximate cause here.
Well, it's a very,
I mean, that's what ABC case talks about, right? Dangerous condition in unloading dock area. Like, at what point is there a detachment between the use of the vehicle and the defects in the premises or in the dock? And that's the interplay that we got to deal with, right?
right, but here you have it is very fact specific, but here you have a situation where you're in a closed construction site. This is just like Stryker. You have a closed construction site. This isn't something that could injure somebody else.
This is a loading dock.
Yeah, but it's
And a loading dock has to be a premises free from danger by its very nature. You have people and vehicles coming in and out with heavy items. So by its very nature, a loading dock is different than a free open construction site.
That's my point, Your Honor. It's a very closed space. He testified very specifically that he could only be there at certain times for his unloading. He had to be out by a certain time. It was a very restricted area. So in this way, it's different from Cosmopolitan. It's different from cases where
How is this different from ABC?
again, because this is part of, we have to look at
But in
each
ABC,
loading-
it's the same. I mean, he's on the loading dock. It's no different. And the person was involved in unloading at that time. And even then, we said that wasn't sufficient, that you had to show an act relating to the vehicle. And we went on to say that simply sustaining an injury during the unloading process without any showing of negligent use of the truck does not invoke liability. Doesn't that language also apply to this case?
Well, Your Honor, respectfully, I think it's hard to reconcile the decision in ABC with the more modern Countrywide and Zurich decisions, where there was a defect, and that was not found to take it out of the exclusion.
I mean, okay. I mean, ABC is 2003 from this department, right? So,
Yes, Your Honor, but Countrywide and Zurich, I think, take a different look a little bit, and they are in 2017, 2018.
okay, thank you, Counsel.
Good afternoon, Your Honors. Gabe Darwick for Respondent Zurich. There's been a lot of discussion about the use issue, and I don't want to spend too much time on it, but I think what counsel has said is that the facts are critical and the case law is not necessarily in alignment. And this court's decisions in Zurich and Countrywide, the two most recent...
Tell me Zurich. How does Zurich apply to this fact pattern?
There was nothing in Zurich that demonstrated, and I argued Zurich and I lost Zurich, and there was nothing in Zurich that was alleged that there was something wrong in the way that they unloaded the vehicle. The allegations in that case, and it's reflected in the decision, were that the way the crates were assembled before they ever got onto the vehicle was negligent. And that was the basis for the claim.
So in Zurich, the accident arose out of the unloading the rebar cages, right?
It arose from the
What
general...
caused the accident.
It arose from the general operation of unloading the vehicle. And this court has held that the general operation includes any acts incidental to the use of the vehicle. And acts incidental to the use of the vehicle here are removing the straps so that the vehicle can be driven out of the premises.
Right, but what's different is, I mean, Zurich is a direct act of loading and unloading. So that's use of the vehicle. ABC is a totally different scenario, right? ABC talks about defects in the premises, in the docking area. So that have nothing to do with loading and unloading.
I think there is a divergence between A, B, C, and Zurich, but I think this case is more aligned
But I think
with-
my colleague is suggesting there's a way of reconciling them because one is use of the vehicle and the other is not.
That's fair, but I think that this case is more aligned with Zurich. And the Zurich case actually adopted the decision in Stryker for supporting its opinion. And in Stryker, the claimant, just like the claimant here, was injured on a premises defect. He tripped over a piece of wood. And that court held that that was sufficient to fall within the use of the vehicle. And we would submit that the court should do the same here since it already adopted Stryker and Zurich.
Okay. Thank you, counsel. One more. She's ready to go. I like that.
Good afternoon, Your Honors. My
Good
name is
afternoon.
Andrew Showers from McMahon, Martini, and Gallagher for the defendant respondent 5-Star. Based upon the proof that 5-Star was not responsible for the accident of Mr. Rodriguez, and accordingly, summary judgment was granted to Zurich. It is our position that summary judgment should have also been granted for 5-Star, dismissing Tishman's and Riverside's complaint.
Well, the claim against you was that you didn't provide proper lighting on the outside of this facility, right?
Yes, Your Honor. However, we weren't
So
obligated.
how does that fit into the theories being espoused by your colleagues?
Your Honor, this case has to do with a hole, and
Yeah, but if the lighting was good, maybe he would have seen the hole.
Your Honor, there was no duty for my client to provide any lighting whatsoever.
Did you make a motion on this issue?
We did, Your Honor, but I believe it was not accepted by the court. I think the court deemed it untimely, but there was no
So
prejudice.
you still want us to search the record?
Yes, Your Honor.
Okay.
And just to pick up where I left off, there was no lighting requirement between the hours that this accident took place. There was no duty on behalf of 5-Star to the plaintiff or any party in this case. This
And
accident.
there's no duty to have lighting outside of a dock, a
Your Honor,
loading dock at 5 o'clock in the morning. Didn't this happen like at 5 in the morning or something like that?
Correct, Your Honor.
It's usually really dark at that time.
Yes, Your Honor, but not as to my client. There was no duty as to my client per the contract. There was a specific time frame that called for lighting from 7 a.m. to 3:30 p.m.
Okay.
Thank you.
Okay. You are.
So Counselor, your adversaries say that essentially Zurich is really the case we should follow. Why do you believe that we should follow ABC and not Zurich?
Well, in Zurich, the individual was actually untying straps that were literally attached to the vehicle when the accident occurred. That is not what occurred here, as Your Honor.
So that is.
It's on a vehicle.
Quintessential unloading, right?
Yes.
You're taking off the strips in order to get the crates down.
Exactly.
So he's actually doing the work. That has been defined as use.
Yes, and yes, and the one case that I mentioned that follows Cosmopolitan was actually decided in 2022, so it's brand spanking new. Wesco Insurance Company versus James River, and now it is New York County Supreme, so it's the lower court. But this is where an individual tripped on gravel while he was in the unloading process, and they found that it had nothing to do with the completed operations doctrine, because anyone could have been walking by and tripped and fallen on that gravel. So therefore, it is not arising out of the use and operations of the vehicle. The issue with 5-Star is, and this is why this entire case was problematic and why we have a 5,000-page record, is because these motions were all made while we were still doing discovery. It wasn't done. Old Republic was trying to get discovery regarding the anti-subrogation issue. We were not granted that issue, and then anti-subrogation was automatically ruled out by the court without any law or analysis on it, and it's still our position that that is first and foremost the reason why. Also, in addition to that it didn't arise out of the use of a vehicle, that they were not permitted to bring this action in the first place. But there was no discovery regarding 5-Star. So instead of us being able to have depositions and have discovery about whether or not the lighting was adequate, instead what Zurich and 5-Star did is they went on the attack on Old Republic and Port Morris and said, no, it's only...
We will have to find as a matter of law that
Yes.
the lighting had nothing to do with it. And I don't know how we can do that.
Well, the way that you do that is you reverse the decisions granting 5-Star summary judgment and Zurich summary judgment, and you allow it to await the decision in the underlying, which is based on the newer case of Burlington, which is you await the decision of the underlying to determine indemnity. You don't give Zurich a granting of summary judgment because Old Republic's policy would be primary. There wasn't even a decision as to whether or not Five Star Electric's policy was hit for coverage. There was no decision whatsoever. And it doesn't really jive that the court said it can only be either a vehicle or lighting. Obviously, it could be either one or both. And so that's why we're saying at the very least, no summary judgments should have been made. We should have continued with discovery, and at the right time, we should have made all these motions. Now, the problem is that Judge Crane, in the underlying, wanted us to move very fast with discovery, and despite the fact that we were having discovery disputes, she refused to allow us to move the note of issue. She said, don't you dare make any motions, and that's why we had to move for summary judgment swiftly before we were done with discovery, Your Honors.
Thank you.
Thank you.
Thank you all. Very good arguments. Yeah, this was, it's not to me, right?
Yeah, I'll see you. You may want to take,
Huh?
uh,
People versus Alvarez?
Hot mic.
Okay.
Good afternoon, Your Honors. My name is Mark Zeno, and I represent Raul Alvarez. May it please the court. Mr. Alvarez was accused of assaulting complainant, his sometime romantic partner, and having committed various degrees of contempt for violating orders of protection by that assault. On a Tuesday afternoon, during his jury trial, he took the stand and swore that he had not assaulted complainant in any way. He swore that he did not strike her with a fist, a hand, or a bottle. He did not commit assault 2 or assault 3 by his sworn testimony. The following morning, during summation, without discussing his plan with Mr. Alvarez,
But wait, before the summation, there was a charge conference, was there not?
Absolutely.
And at that charge conference, the defendant heard his attorney ask for a lesser included of assault in the 3rd degree, correct?
That's correct, Your Honor.
Did he object to that?
No, in fact, that was a strategy he wanted. He wanted assault in the 3rd degree submitted as a lesser.
Okay.
But agreeing to submit assault in the 3rd degree as a lesser is not an agreement to concede guilt to that crime. And during the 440 hearing, counsel was asked that specific question. Whose decision was it to admit guilt, to concede guilt, or to insist on innocence? And here's what counsel said. It was Mr. Alvarez's decision. He exercised that right during his testimony, meaning he said he was innocent. But it was also agreed, as far as my understanding goes, that in the alternative, if that complete defense is not accepted by the jury, we will argue at most that he committed assault.
Mr. Zeno, is there any evidence or any proof whatsoever that your client told counsel to pursue an absolute innocence defense?
Well, there's hearing testimony that my client testified as to that, and there's hearing testimony from counsel that he understood. Counsel understood that he only wanted a complete innocence defense. It's all over the record. Anytime that counsel was asked what was the strategy that you discussed with your client, he said that we agreed to submit the lesser in the alternative. He swore on the stand on a Tuesday afternoon that he didn't do it. His lawyer got before the jury the next morning and said he did do it.
Counsel, during your client's testimony, he admitted on the stand the criminal contempt charges.
He admitted
being near the victim, which was in violation of the order, correct?
Right.
So that even if counsel had not made the statements he made about the 3rd degree, there was going to be a conviction on the criminal contempt either way.
Disagree, Your Honor.
Why?
He said that the complainant came to him at
It
his
doesn't matter. You and I both know that the law on that is very clear.
Disagree.
Even a victim give permission to someone who has an order of protection against them.
Disagree, Your Honor. It has to be an intentional act. My client's testimony was that he was at his motorhome, underneath his car, fixing his motorhome when his client showed up. And in any event, that only goes to the two most minor contempt charges, not this aggravated contempt charge for which he got a 3.5 to 7 year sentence. Those involved an assault. Those involved a finding that he had assaulted the complainant.
I understand, and the jury heard his testimony and everybody's testimony. And they considered it. They obviously did not believe him.
And in McCoy versus Louisiana, the Supreme Court said it is structural error, not subject to harmless error analysis, that a lawyer cannot concede guilt over his client's objection. And it could not be more.
But you had to prove by a preponderance, right, that that's what he actually wanted, right?
Well, the lawyer admitted that's what he wanted. The lawyer admitted that he understood that his client was pursuing a complete innocence defense. That's what the lawyer said at the hearing. And let me back that up.
But the fact that, counsel, a lot of defense attorneys find themselves in that situation where their client is unable to accept what happened. They want to continue to profess their innocence. And as a trial lawyer, this was a defendant who was looking at serious time if he went down on the assault, on the assault 2 charge, right? I mean, he was looking at persistent violent felony offense level time, so that the strategy of a misdemeanor assault was brilliant and saved this defendant years and years of time in jail.
May I respond?
Go ahead, Mr. Senior.
We do not know that. The client consented to assault 3 in the alternative. The jury may well have found assault 3 in the alternative if the lawyer had argued he didn't assault, there was no assault at all. Believe my client, believe what he swore to you. But if you disbelieve there was that, then there was no assault with a weapon, therefore assault 3. It was an alternative. And one more point. McCoy versus Louisiana says it does not matter how bad that trial strategy is. In that case, it was a death penalty case where the trial strategy that the client would have insisted on could have led to the client's execution. And the court found that regardless of whether it was a good strategy or not, it was the client's decision to make, not the lawyer's.
Okay, thank you.
May it please the court, my name is Grace V. I represent the people. After conducting a very thorough hearing at which he heard both Mr. Herlick and defendant testify and assessing their credibility about their versions of what happened here, Justice Hong properly concluded that Mr. Herlick had informed defendant of his trial strategy to concede the defendant's guilt of third-degree assault, and that defendant had not expressly objected to defense counsel's concession of this lesser-included offense. I would submit that there was, and it was proper for Justice Hong to credit defense counsel's version of what had happened, because it made sense.
It's your position that the defendant should have gone on the record and interrupted his attorney and gone on the record and said, I object to that?
Well, Your Honor,
I've never seen that happen.
Sure. That's maybe one component. What I would submit is that the fact that Mr. Herlick said that the defendant never objected when he submitted the lesser-included offense, and that also went on during summation, he conceded the guilt of third-degree assault. Importantly, it's that Mr. Herlick said, defendant never said to me that he objected to that or expressed surprise or objection in any way. And that was the testimony at the 440-10 hearing, which Justice Hong credited. And I would submit that, and it made sense for Justice Hong to credit that testimony because, as he said, it's a he said. And he chose to credit Mr. Herlick's testimony, a seasoned attorney who had a lot at stake if he were to be lying, that he had discussed this with his client, and that his client had at a minimum acquiesced and certainly did not object to this type of trial strategy. And that's why we would submit, people would submit that actually McCoy versus Louisiana is really not applicable here, because in that case, I'm sorry, excuse me, in that case, the Supreme Court, the issue was whether it was unconstitutional to allow defense counsel to concede guilt over a defendant's intransigent and unambiguous objection to a concession of guilt.
If the defendant were able to prove by a preponderance that he absolutely told counsel that that he wanted to pursue an absolute innocence defense, and the court were to credit that testimony, that's sufficient. I mean, the issue here is you have the attorney, Mr. Ehrlich?
Mr. Ehrlich.
You know, testimony and defendant's testimony, and the court chose to credit the attorney.
That's right, Your Honor. Exactly, exactly. If it were differently, if he credited that defendant had said, absolutely, do not want to, I want to pursue an absolute innocence, and I don't want any concession of any guilt. If Justice Hung credited the defendant's testimony in that regard, we'd be in a different situation here. I do feel that the people would have to concede that McCoy would probably apply, and that would be a different situation. It's a credibility determination here, and I would submit, I would urge Your Honors, that Justice Hung's credibility determination here, that Mr. Ehrlich did advise the defendant of this trial strategy of submitting the lesser included offense of third-degree assault, and then ultimately at summation,
But you see, the other side now, right? The fact that the defendant would be convinced by an attorney saying, look, man, you're looking at a lot of time, we should have an alternative of assault 3, doesn't mean that the defendant said, okay, I won't assert that I'm fully innocent. The two are not mutually exclusive, right?
I think I understand
so
what
the
you're saying,
defendant could have said, okay, that's all right as an alternative, thinking, as counsel said earlier, that his attorney was going to argue, my client is innocent. He didn't batter this woman. You heard him testify, blah, blah, blah. But if you don't believe that testimony, the injuries are insufficient to rise to the level to... There would have been a way to argue the alternative without conceding innocence, is my point. So the fact that he didn't object to the charge doesn't mean that he didn't object to his lawyer arguing that he actually did commit assault.
Right. I understand. I think I understand what you're saying, Your Honor. And turning to the ultimately the concession that defendant was guilty of third-degree assault, but not second-degree assault, the defendant for this to be a legitimate McCoy claim, there would have to be credible evidence that the defendant at no time objected or told his attorney, I do not want you conceding guilt of
So we go back to that same issue I raised.
And you're saying that his testifying that he didn't do it was insufficient to communicate that?
Correct.
Okay.
That's correct.
Thank you.
Thank you.
Okay, Mr. Zeno, I'll give you the 2 minutes.
Thank you, Your Honor. If there were testimony before the hearing court that concession strategy was ever discussed, then my client would have had an obligation to object. It was never discussed. The lawyer was asked at the 440 hearing whether he understood that it was his client's defense that he had not assaulted complainant. The lawyer said, yes, I understood that was his defense. He also knew I was going to ask for assault third degree as a lesser included offense as an alternative to assault in the second degree. He never said he was going to concede. In the prosecutor's brief, they use the word concede more than 10 times. Concede was never discussed at the suppression hearing. Yes, Judge Hong had the ability to resolve credibility in favor of the lawyer against my client, but it was never uttered that the concession strategy was discussed. And if there's one thing that's clear about from McCoy and Nixon, and that is that it must be discussed. A defendant can't be expected to object to a strategy if he isn't told what the strategy is. And at every point in these proceedings, my client maintained his innocence. When he was arrested, he told the cops, I didn't do this. He waived Miranda and made a videotape statement in the prosecutor's office. I didn't do this. I didn't assault complainant.
Well, did he concede that he had committed the criminal contempt?
He did not concede that, Your Honor. He did not concede contempt. He said that the complainant showed up at his motorhome. And this did take place at the motorhome. I mean, I don't want to get into credibility of the complainant here, but her story that she just happened to be jogging by his motorhome while he was there is somewhat incredible. But getting back to my client's insistence that he was innocent, when he waived Miranda, he offered to...
We also had a witness here who saw, right? I thought there was a gentleman who saw her running out of the van.
Yes, and
with blood and blah, 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 right?
But it's not about whether he was guilty or innocent. It's about his right to insist on a trial strategy that he was innocent. The lawyer, I ask you to peruse the record here, the lawyer never once revealed a strategy that he told the client that he was going to concede. Every time he was asked at the 440 hearing, did you say that? He said, I discussed it as an alternative. A client can't be expected to object to a strategy he doesn't know about. He didn't learn about the strategy until summation.
Okay, thank you, Mr. Zeno. Thank you both. Nice and toasty here for you, Angie.
I think it's cold.
This is cold.
No, I asked for it.
And trust.
Oh, my goodness.
She says it's cold.
I'm hot as hell.
I know that.
Yeah, no, I asked her already. Okay, so we have Amtros North versus Pavlov and Prost versus Amtros North. So let's
Good afternoon, Your Honor.
start Mr. Pavlov, 7. Okay.
Good afternoon, Your Honor. Michael Furman on behalf of appellant Sherry Pavlov. I'm here arguing 2 appeals. So I'll argue them both at the same time.
That's fine.
Okay.
That's fine. That's why I gave you 7 minutes.
I appreciate that. Thank you, Your Honor. First, I'll address the Amtrust claim. Your Honors, that claim fails to state a cause of action for legal malpractice. The court below made a grave error. The record is absolutely clear that it was a mistake by a claims adjuster, admittedly 5 times, many times, more than 5.
Did your client...
On the record that he admitted he made a mistake.
Sorry, counsel, this is Judge Singh. Did your client happen to peruse the order, the underlying order here? And by the way, 3 of us were on that prior appeal, too. Did your client peruse the order?
My client did. She learned of the order just like counsel for the plaintiff learned of the order before August 10th of 2000.
Did she look at the order? Did she have it in her hands? Did she peruse it?
She had an opportunity to look at it on a gadget.
Okay.
She wasn't given, and this is the most important
So
part.
she had the opportunity to look at it. She perused it and presumably didn't read it in great detail.
But that's the point. It's all,
So how is there a mistake there? How is that a mistake?
Well, see that, yeah, I'm trying to answer the question. But that's really the critical thing, is that my client was retained for a very distinct purpose. This is, and it's
No retainer agreement, correct?
I'm sorry?
Was there a retainer agreement saying specifically what your client was retained for?
No, we have better. We have testimony at page 701 of the record. Testimony from Mr. Kuhn.
Better than a contract? I don't think so.
It's even better. It's even better, Your Honor.
Really?
Because he says specifically, under oath, what he retained Sherry Pavlov to do. And then, this was in December of 2016, and it was specifically to address the issues related to Great American having problems with the fact that Amtrust had tendered $5 million. Great American thought that was bad faith because they were the excess carrier above, and they thought you're just throwing that money at the plaintiffs, and you're exposing my layer. So, Your Honor, absolutely it's better than a retainer. It's testimony under oath as to what she was retained for. Then, you have in the record a report by by my client saying 2 weeks later, here's what you do with that issue with Great American. And it's a report, it's in the record before, Your Honor, a few weeks later.
Yeah, you're running out of time and you still have the other appeal to do. Can you tell me what documents and what evidence you submitted to utterly refute the factual allegations that are made in the amended complaint?
The testimony over and over, pages 665 through 680 of the client, Kuhn, the claims adjuster for AmTrust, who says over and over, I made the mistake. I thought when I sent the letter before my client was retained in November of 2015, a letter to the plaintiff saying, here's $5 million, here it is.
But there wasn't a problem then because there wasn't the conservation order yet.
That's correct.
So the problem doesn't happen until after the conservation
and
order.
my lawyer,
and who's the lawyer?
My lawyer is not the lawyer for the conservation. My lawyer is a New York
I
lawyer.
know, your lawyer,
Right?
your counsel, the lawyer was the attorney for AmTrust, no?
For a very specific purpose, to address the bad faith issues with Great American, not to deal with the liquidation. In fact, she wasn't even aware of it, about the need for going to California to get authority. Only Q knew that. He never told my client, oh, by the way, I offered $5 million, but now I had this meeting that you weren't aware of, and I now have to get authority to give that $5 million. My client wasn't told that. How can she be responsible for that?
The order said it, right?
No, the order didn't say that there was a specific, it just said that all of the settlements had to be approved by the liquidation.
That's kind of clear, counsel, and I heard you say that the order was on a device, is that right?
I'm sorry.
You said that, sorry. You said that that the order was on a device and that it wasn't actually provided to, it wasn't given to your client.
No, she was never given it to her. She was never given the role to give advice on it. It would have been gratuitous if she would have given advice on that. She wasn't instructed or asked to, hey, take a look at this California order and tell me what to do about it. And there were meetings that my client was involved in.
I'm just flummoxed by the notion that you would ask your client for legal advice. And you would rely on your client's interpretation.
No, but it's not, that's the whole point. There was a procedure. Again, it's in the record, pages 666 to 680. There was a procedure that AmTrust had in place internally on how they handle claims. Mr. Kuhn was under the impression that since he had made that offer of $5 million before the liquidation, that he didn't need to get approval. So my client wasn't told to go back and look at.
Except if your client had read the order carefully, whether it was on a device or anything else, she may have advised the client differently.
She would have committed malpractice by giving advice on that.
Really?
Because she wasn't asked to do that. She wasn't, in fact, that's a California order. How could a New York lawyer interpret that? In fact, Mr. Kuhn, again, to the record.
What is there to interpret? You have to get approval for a settlement number. There's not much interpretation there.
Mr.
So
Kuhn,
all,
I can answer that
you
question.
go ahead, because you want to talk, so go ahead.
I apologize, Your Honor. But Mr. Kuhn testified that this is an area of law, of specialty. He testified to that he would never have asked my client to interpret. Again, that's at page, I think, 679 of the record.
Instead, let's rely on me, a claims adjuster, not a lawyer, my interpretation of it.
You're saying that a lawyer should protect the client from themselves?
Yes.
Yeah.
Imagine that.
That's the
I mean,
job
imagine
of a
that.
lawyer.
But when they admit
Did
that
you hear
they
the
made a
argument on the
mistake
last case?
Ay.
Imagine that.
You heard the argument in the last case, right? Your time ran out, counsel.
Okay. Thank you, Your Honor.
Okay.
Thank you, Your Honor. Michael Brown, Ruskin, Moscow, Faltichek for AmTrust North America. Your Honors, Ms. Pavlov thought the order was important enough that she went and got it. But she testified.
But your
that it gave it
adversary's
to her.
position, quite frankly, Counselor, is we were retained for a very limited purpose, nothing to do with the order, and therefore, there could be no malpractice under those circumstances. Why do you, what do you say about that?
Well, that's, quite frankly, the statements are just wrong. The representation was not limited at all. And Mr. Kuhn, when asked about what the representation was, is she was supposed to protect AmTrust and the insurer for everything that the defense counsel wouldn't do. Now, the defense counsel's obligation is to defend his clients, not the issues relating to the insurance company or to AmTrust. So she said that she was retained to represent the client's interests, and the interest was there. Now, to say...
So in the absence of a retainer agreement, can we decide that issue as a matter of law?
I think it's a question of fact, Your Honor, but let me just be very clear. They say that this retention was about Great American having a bad faith claim against AmTrust. Now, the actual demonstrated facts refute that. In November of 2015, there was an offer of $6 million to Ms. Pruss made by AmTrust, by the insurer, and by Great American and others, $6 million. The primary insurer had $1 million left, and then there was AmTrust money. In April, Great American, who had control of the settlement conversation by Mr. Kuhn having had the authority to give them control to argue with their own money, raised the offer from $6 million to $9 million. So by definition, offering $3 million more of its own money. So how could Great American claim after that AmTrust had offered the $5 million too early? It's impossible. So this is a red herring. There is no question about the scope of the fault. There is no written retainer agreement. The excuse that it was limited to this mythical bad faith thing, if it ever existed, was over in April of 2016. So why is she going to the settlement conference in August? Because she had a broader representation, as Mr. Kuhn testified very clearly. Not only didn't
she reach out to confirm that money was still on the table?
No, Your
$5
Honor.
million, or didn't she say that she called to confirm with Mr. Kuhn whether the $5 million was still on the table? And my understanding of the record was that she did that because she knew there was this California order, and there was a settlement conference. She wanted to know whether that money was still available. She was going to be appearing before Judge Silver.
She testified that she had a conversation, and she's all over the map as to what the conversation was with Mr. Kuhn. Mr. Kuhn did not recall the conversation. After the original complaint was drafted, we got records from AmTrust which showed that from the bills that there was absolutely no reference in Ms. Pavlov's invoices saying that she had spoken to Mr. Kuhn. They then went and got the claim notes from Mr. Kuhn that he keeps. There was no reference at all to a conversation with Ms. Pavlov, and therefore the amended complaint takes issue with that claim that she spoke to Mr. Kuhn and sought approval of that. But she didn't ask Mr. Kuhn, what was the basis for your belief that your original authority going back to 2015 was still valid in the face of the conservation order? She didn't ask him, do you have the authority of the conservator? She didn't ask him, are you aware that there's a prohibition in this order? None of those things. It's not just that she didn't just read the order. She didn't ask any of those questions knowing there was a conservation. And she testified at deposition when forced to read the order that she did understand it. It's in plain English. She's a sophisticated lawyer who is a coverage litigation lawyer who can read a court order. It says, thou shalt not do this. Mr. Kuhn's mistake, and he didn't ignore his instructions. He thought that his prior authorization required.
Thank you, counsel.
Can I say one thing, Judge?
I'm giving you folks a lot of time, and it's the end of the day. I will give you 20 seconds.
Your Honor, Rule 1.4b of the Rules of Professional Conduct state a lawyer shall explain a matter to the extent reasonably necessary to permit the clients to make informed decisions. Ms. Pavlov did anything but that.
Thank you,
Your Honor.
Next.
We were going to be arguing them together, so now
I'm very confused, Your Honor, because we just
well, I
went
tell you
from-
what.
With 3 appellants, we just went from appellant to respondent.
We had appelling in the armed trust. Ms. Pablo is the appelling in the armed trust, right? And then now you have Pavlov and Farber Brooks and Lester Schwab are the appellant on the other case, on the Prost case.
Farber Broxane is in both, but I thought we were arguing them together.
Together, that's what I thought.
So so I don't know. I feel like I got skipped a little bit, but that's probably my fault.
You know, you got to get on the batting box quickly.
I'm sorry, Your Honor. I don't recognize everyone.
It doesn't matter. I'll give you. I'll give you the time. So tell us who you are and who you represent.
Yes, I'm John Watkins from Coffee Modaiko, Amira Kapowski, and I represent Farber, Brox, and Zane in both of the appeals. So I just wanted to, I have only one unique issue, which I can get to in a moment, which is the 487 vicarious liability issue.
Right.
And I don't know if you want to hear me address that since it didn't come up in what was just discussed. It's our position.
They chose not to raise it. I mean, the question to you is there a chronic pattern of legal delinquency here?
No.
That will sustain a 487 claim?
First of all, the answer to that is no. What there is,
I mean, they didn't raise it. They had the 487.
There's at most, sorry, Your Honor, I apologize for talking. There's at most one debatably inaccurate statement, which is that Attorney Pavlov said, I was not provided with the order, which when she had access to it, but had not been provided it by her client. That is at best a debatably misleading statement, rather than a consistent.
So you're saying even if it is deceitful, it is not a chronic pattern of legal delinquency that will sustain a 487 claim?
Correct, to the point where it's
that.
very clear if someone said, I was not provided with it, and someone said, wait a minute, what do you mean, provided or what? We don't know what she would have answered. We don't even know because
we got
So
that.
she left the impression she had no idea what the contents of the order were.
At a
Let's not play games, okay? She used the word specifically, I wasn't provided so that she could, because that was a true statement. She wasn't physically given the order. But did she have it and have an opportunity to review it? Yes.
I would say that those are two different things, Your Honor, in the context of a client pursuing a legal malpractice claim where the client is saying, you didn't do what I asked you to do, and you're saying, what are you talking about? You never provided it to me.
But what we're talking about is what she said to a judge.
Correct.
Right? Not to her client. She's talking to the court. And she made it seem in her statement, look, I read the statement, okay? And it was a perfect lawyer,
artful
way of saying something to leave the impression she wanted to leave and still say, I was truthful. I get it. But did she mislead the court? Absolutely.
Well, I have to disagree with that, Your Honor, but I'll move on to the next point, which is, regardless of that, there's two other problems with the 487 claim. One, that statement is made after the settlement had been entered into. Ergo, there could be no possible damages traceable to it. And second of all, as to my client, Farber, Brooks, and Zane, 487 is not a vicarious liability statute, so my client should be out on that. That argument is in our briefs. If I may have just a moment to address some of the things that I heard previously, I just would like to draw your attention to a couple of things in the record. I did hear a reference to the mythical bad faith claim, but of course, Mr. Kuhn testified to the bad faith claim. It's on record page 701. So we would dispute that that's a mythical claim in any way. And I would just like to draw attention, and I know I just touched on this a little bit, to the point that this case would be a completely different case if the allegations or the evidence were that what had happened was AmTrust, which is a large and sophisticated insurance company, had asked Attorney Pavlov, please advise us as to whether we still have the authority to offer this settlement after the conservation order had been entered. In fact, that is not what the evidence is. In fact, the evidence is that AmTrust never sent this to Pavlov, never asked her to review it, and never relied on her advice. And what's more, Mr. Kuhn went even further and said he never would have asked her or would have relied on her to do so. It would be a very different case if that weren't what the record shows, but that is what the record shows. And that is why there is no reliance on any advice here. And that is why this does not state a claim on which relief could be granted.
Thank you, counsel.
Thank you.
Next batter.
Not until tomorrow.
Not until tomorrow, right? That's true.
May it please the court. My name is Marion Rice, and I represent Lester Schwab, Katz and Dwyer, who are appealing the trial court's denial of its motion for summary judgment. Unlike the last people that you spoke to, my client was an insurance defense firm retained to represent Infinity Toyota in the underlying personal injury case. They were not coverage counsel. They were not asked to be coverage counsel. They were simply representing their client in that case. Their motion for summary judgment should have been granted. The record fully rebutted both the negligent misrepresentation and the judiciary law claims. While the plaintiffs have a very colorful way of trying to rebut the facts that are presented in the record as to my client, in fact, we're here for only one reason, and that is because AmTrust made a mistake. AmTrust admitted it made a mistake. My client, when they learned the conservation order, contacted senior officials at AmTrust and were told to deal with the claims attorneys. And they did. Before the settlement conference, my client called Mr. Kuhn and said, in light of the conservation order, where are we tomorrow? He said, no problem, I've got the money. My client went to court then. He pushed back. He said, are you sure? And Mr. Kuhn said yes, and he admitted all of this, which was nice to see because there was not any paper on it. So we go to court the next day, and here's the extent of the deceptive conduct that my client exhibited. When called to the bench, my client said, Judge, you need to know this, the carrier's in conservation. Despite this, I've been authorized to extend the $5 million. That was the end of his statement in the court. The court then turned to Ms. Pavlov and said, she confirmed that the money was available, and that was the end of it. The court went then on to speak to counsel for the next excess layer, and then went and spoke to plaintiff's counsel. The case was settled, a stipulation was entered and signed by the court. My clients might disagree with me, but this half of the panel was absolutely correct in 2020 when you ruled that attorneys have actual apparent authority to bind their clients in court. But that's not the issue we have here today vis-a-vis Lester Schwab. Lester Schwab appeared there as the agent of disclosed principal, AmTrust, who had made a mistake and who admitted they made a mistake. They did not give advice in connection with it. They did nothing. They did not color the message that AmTrust wanted delivered that day. They simply delivered it and left. It would be no different if Mr.
And they were speaking as the agent
Correct.
of the principal.
For a disclosed principal. That's correct, Your Honor. They should not have any additional duties put upon them to try and separately investigate something that someone relayed them, not in a legal capacity, but as an agent to deliver to the court. It would be no different than if the judge had called AmTrust and say, where are you on the settlement? It's the same type of thing. So if I could turn for just 2 seconds to the judiciary law claim. Clearly, the conduct that was exhibited by Lester Schwab was not deceptive. There's no pattern of deceit here. There's not even a misrepresentation. They accurately conveyed what was told to them, no more, no less. There's no basis for a judiciary law claim. Counsel with a broad brush says what happened afterwards, after the settlement conference, supports a claim of a continuous bad acts. It doesn't. All it does afterwards is show that, unlike most every other case I've ever been involved in, the carrier, AmTrust, insisted on drafting the release in this case. My client conveyed the release to the plaintiff's attorney. Plaintiff's attorney had it executed. It was approved by higher ups in AmTrust. They asked for the settlement check, and it was not until 2 months later that my client found out there was a problem. Quite simply, my client doesn't belong in this case, and the summary judgment motion should have been granted. Thank you very much.
May it please the court, Paul Edelstein on behalf of Respondent Eddie Pruss. I think it should be my turn to talk. I got some help from AmTrust. Let me start by saying anything I say today, if I make a misrepresentation or I commit deceit to this court,
Counselor, can we start from the basics with respect to the negligent misrepresentation claim?
Absolutely.
You understand what the law is. How do you fall within privity or privity-like relationship?
Well, because under Prudential and the Credit Alliance analysis here, it has to be a statement made to a known party. Obviously, these lawyers made the statement directly to a known party, the court, and really, by extension, me. They had to make the statement with a specific purpose to get the case settled and known that it was a significant thing that people were going to rely on, namely me, a known party. And then they had to evince something.
What's the privity-like relationship? I'm still not understanding. What is the privity-like relationship?
It's a special relationship created between these two attorneys. All of these cases.
So in every settlement case in this state now, we're going to say that there's a privity-like relationship, but when we have settlements and things go awry?
Yes, when you're talking about a case settling, you're going to have to do that. Yes, otherwise we could never settle cases.
Akin to contractual privity?
Well, it wouldn't be.
What's the authority for that?
There actually was a contract then, drafted that day in court. So you really could say, because not only did they say this, but they did contract it in court and so ordered it, and then followed up with other contracts releases. So really there are contracts here too, but I don't even think you need the contracts. Yes, I think this court, much like you did when we were here in 2018, needs to say when attorneys, even adversary ones, come to court.
Well, but except that case was based on apparent authority, and there's a case law that goes back decades on that issue.
I absolutely agree. But when you, Judge Acosta said, to do otherwise would turn the practice of the law on the state on its head, that would also apply to this scenario.
No, but that was just a reference with respect to representations made in open court to the court. That has nothing to do with whether the defendant owe a duty of care to you.
Same thing applies here. Imagine if I had settled the case as a plaintiff.
What's the authority for that?
There has been no case where a settlement was breached in this context. But attorneys shouldn't be immune.
So there is no precedent for this?
There is no precedent for a settlement being breached based on a misrepresentation to a court by a defendant or a plaintiff. If it happened the other way, I think I would be in just as much trouble if my misrepresentation caused the defendant damages. There were consequences to this conduct, consequences to the things they said that day, millions of dollars of consequences. They're asking you to immunize that.
Were you made whole?
I'm sorry.
Were you made whole?
No.
You weren't
not
made
even
whole?
close to whole.
You didn't get your 1/3?
Not even close. No, absolutely not.
You didn't get a third of the settlement?
Attorneys as a whole received a third
were
of
you
something.
made whole
No.
in the underlying litigation?
No.
Did you get, in accordance with the retainer agreement that you had with Ms. Pruce, did you get what you were entitled to?
We did not get what we would have gotten had the case settled 6 years ago.
That's not answering the question. You see,
$5 million.
That's very artful.
No,
you know,
$5 million was paid.
Are you misrepresenting to the court?
Not at all.
Why don't you answer the question directly?
$5 million was paid to this client ultimately, but it cost more than $1 million to get that $5 million.
Okay.
So I have to take that into consideration. If the question is, was the $5 million ultimately paid? The answer is yes. If the question is, did attorneys ultimately get a contingency fee on that $5 million? The answer is yes. But it cost more than $1 million and 300-something thousand in expenses to get that. Those damages were caused by these lawyers, nothing else, and they're asking you to immunize that. So yes, I do think you have to issue an order saying you must be bound by the consequences of your actions, just like I should be bound by the consequences of my actions here today or in any other court on behalf of my client. I can't turn around and say, my client was a disclosed principal in an agency case, and it's really her fault. She told me to settle the case and then changed her mind. If the situation was reversed and I was before you, I would be eviscerated here. If they suffered damages, you would say you caused them damages by pledging a settlement in court that you couldn't do. That's what they did. This is a very simple
Is there anything that she said or did that will substitute her personal liability for the principal that she's representing?
Ms. Pavlov, you're talking about? In order for them to use this disclosed principal argument, they have to have a specific contract that carves out and says, I'm not responsible for something my principal is promising you. As all of you said, there's no retainer.
What's the authority for that statement?
All of the cases, all the disclosed principal agency cases that they cite. That wasn't really raised below, but it was raised here, but I don't care, because all of those disclosed principal cases that they cite
I don't
stand
think
for the
that
proposition you need a contract.
I don't think that's accurate law, but okay. Let me hear from the next person.
Who that would be? I guess it would be.
That will be Appellant, 2 minutes.
Rebuttal. And just let me use, a part of my 2 minutes to apologize to Justice Manzanet. I apologize.
No need to apologize.
I-
This is, look, the law is a combat sport, as my PJ likes to say. I take no personal umbrage.
It's the South American in me that I'm passionate about my
Well, I'm
position.
Latina, so there you go.
All right, so thank you, Your Honor. Thank you for giving me the opportunity. Your Honor, I couldn't address everything obviously in such a small amount of time. It's a lot of briefing. The only thing I would ask Your Honors to do is to look at the record specifically where Kuhn testifies between pages 665 and 680. A lot of the arguments that we've made in our papers are contained right in there. It addresses the duty argument, the causation argument that we make in terms of legal malpractice, and finally, in terms of dealing with the claim by Pruss.
No, we've read them, including the duty argument, whether there's a duty of care that I think only lies in the context of a special relationship, but I'm hearing that there's precedent for something else that I didn't know about.
Well, right, and I think the remedy there, of course, is a breach of contract claim against the party that makes. That is ultimately the remedy that would be there. So thank you, Your Honors. Again, Justice Manzanet, thank you for the opportunity. All right.
You got it. Thank you, counsel.
We finished?
Okay, let me hear from the other appellant who gets 2 minutes.
I will be very quick, Your Honors. I just want to address the issue that somehow Mr. Edelstein thinks that I am arguing that attorneys should get a free pass for bad conduct. That is not the case. Attorneys who cheat or lie or who deliberately mislead somebody, they deserve to be held accountable.
We understand. The issue is whether the attorney should be personally liable when clearly she's arguing in behalf of a disclosed principle.
Correct.
So you don't assume personal liability.
Correct.
When you argue, otherwise there'll be a lot of lawyers in trouble.
Judge, I think you finished it for me. Thank you very much. Have a good day, and thank you for your time.
Thank you all.
Last but not least. Ferguson. Huh? Ferguson. Isn't there another one?
Sí, ese.
In that thing about people be Ferguson.
Right. Okay. Yeah. They're lucky we can go late because the Yankees are not playing. Go ahead, counsel.
Good afternoon, and may it please the court. Alexandra Mitter on behalf of appellant Gregory Ferguson. The night that the complainant, Raymond Vargas, was shot, 3 witnesses described a man leaving the scene who did not look like Mr. Ferguson. He was shorter, he weighed less, and he was described variously as white/Hispanic or light-skinned, while Mr. Ferguson is unquestionably a man of African-American descent described as dark complexion.
The jury have credited Vargas's identification of the defendant. After all, I think he met him at a restaurant earlier that day and probably knew him from before.
So there's no question that Mr. Vargas was familiar with Mr. Ferguson. The problem is that this is simply not a reliable identification. no part of the complainant's description of what happened jives with the objective evidence. Everything he said happened simply is not borne out by the crime scene.
Except that the description, I mean, do the EMT records state who the affirmant is?
I'm sorry, the EMT records,
Yes.
Your Honor? That we don't have EMT records. There was an EMT technician who testified who said that the complainant told her that his wife's son, his son, shot him, and she was in no uncertain terms. She asked him for clarification. Are you sure?
But those are EMT records because they take them as part of their duty to take that information.
No, Your Honor. The EMT was in the process of leaving the hospital, having dropped off a patient, when the complainant was brought in a car. She heard someone screaming for help. She ran over to help, and as she's bringing the complainant to the trauma bay on a gurney, she's saying, "What happened to you?" And the complainant says, "My wife's son shot me." She says, "Are you sure?" He says, "Yes, my wife's son shot me." She's like, "I've heard people who don't make sense before, and my job as an EMT. I am confident that that is what the complainant said." And to be clear, I'm not saying that the complainant's son shot him. I'm saying that
The complainant in a state where he was almost
Yeah.
on the verge
leading
of
to
going into a coma or going into a state of unconsciousness and had lost a large amount of blood at that point?
Yes, absolutely. The complainant was.
He'd been shot, what, how many times?
He'd been shot two or three times. It's not entirely clear. And to be clear, what I'm saying is that the complainant is not a reliable narrator of what happened. He says he was shot in the face in his bedroom. There is no blood in the bedroom anywhere.
But those discrepancies where, I mean, usually when you wake up with a pillow on your face and somebody that has a gun in their hand, you know, there are going to be some discrepancies. They were all before the jury, right?
They were all before the jury, and respectfully, the jury got it wrong. That is the purpose of this court's weight of the evidence review power. The jury simply got it wrong, because whether Mr. Vargas was misleading the jury intentionally because what actually happened painted him in a very unfavorable light, or if he was simply confused because, as Your Honor pointed out, he had undergone serious injuries, and the first thing he remembers after waking up is being shown a picture of him and Mr. Ferguson standing together. That is highly suggestive under the circumstances. Whether that's the reason he identified Mr. Ferguson or he did it because he was involved in some shady business and that was why he got shot in his apartment, it's hard to say, but under any circumstance, this court should have no confidence in the jury's verdict. I think the complainant's testimony combined with the pervasive Brady violations should give this court serious pause in Mr. Ferguson's conviction. The prosecution prevented Mr. Ferguson from following crucial exculpatory leads for years while his case was pending. And these Brady violations denied Mr. Ferguson his due process right to a fair trial and to present a defense. There's absolutely no question that these were Brady violations. That's already been decided. The issue here is that the remedies the court provided for those Brady violations simply weren't enough. This case is exactly like Robertson, which we cited in our brief, where, as here, the prosecution did not disclose exculpatory witness information, and as here, as a remedy for that, the
I'm sorry,
court allowed...
I think I know where you're headed with this, but what is exactly the exculpatory information? That's what he viewed in the hospital?
Pardon?
Is it what the victim saw in the hospital? Is that what you're referring to?
There's a number of categories of exculpatory information. There's what happened at the hospital, which all records of have been completely erased by the prosecution, and then there's also the fact that 3 witnesses described someone leaving the scene in the immediate aftermath of the shooting who did not match Mr. Ferguson. Both of those exculpatory leads were precluded from investigation by Mr. Ferguson because the prosecutors would not turn information over sufficient to allow him to follow up those leads. With respect to the...
As to one, I think you're talking about Curry, who
Yes.
as I understand it, is homeless. So I'm not sure what information the prosecution could provide you. Who else?
He was not homeless at the time, Your Honor. He lived in that apartment building. And so had the prosecution disclosed that information before he became indigent and transient, the defense counsel could have spoken to him and followed up that lead and made sure that
You're saying
stayed
the
in contact.
defense attorney didn't go to the scene of this crime right after getting the case and finding out who lived with his client? Your client couldn't tell you that?
I'm saying that's exactly what happened, Your Honor, and that is why we have a 440 claim. There are a number of potential leads that, frankly, the respondent acknowledges went unexplored in her brief that deserved a 440 hearing, and frankly, the trial court's decision to deny the 440 motion without a hearing because an affidavit hadn't been provided by counsel is contrary to this court's law up and down. Mr. Ferguson explained that he tried to contact his attorney and ask him for an affidavit, and the attorney refused. And so if this court does not reverse the conviction, we would respectfully ask that we have the opportunity to have a 440 hearing where Mr. Ferguson, represented by counsel, can make those claims.
Thank you. Thank you, counsel.
Good afternoon again, Your Honors. Jennifer Watson for the Office of Darcel D. Clark. The people respectfully request that this court affirm the judgment of the Bronx County Supreme Court. To get to defendants' purported Brady claims, as Your Honors asked, what exactly was exculpatory about this purportedly undisclosed evidence? First, the descriptions provided by those witnesses were not significantly at variance with that of defendant.
Stop. Stop. You cannot make that argument where we have a dark-skinned black man and the description is a white Hispanic. Those two things are as diametrically opposed as can be.
Your Honor, if I may answer that?
Please.
Officer Ben Cosme, the officer who spoke to those witnesses, wrote the following description in his memo book. He wrote, light-skinned male, 5'8", 165 pounds. In other police paperwork, he conceded that he checked Hispanic as a possible descriptor, but he could not recall if the witnesses had said that, and he had no independent recollection of those interviews. Second, during trial, the complainant, Raymond Vargas, who, as Your Honor pointed out, was quite familiar with this defendant, described him thusly: a light-skinned black man, about 5'8" to 5'9", about 170 pounds. The description upon which defendant would like to primarily rely now is that of Detective Mina, the arresting officer, who solely interacted with the defendant at the time he processed his arrest. He got the information of height and weight from defendant himself. Defendant reported his height and weight at 5'10", 190 pounds. And he, Detective Mina, described defendant as a black man with a dark complexion. So we have these three descriptions, all of which were provided to the jury.
So are we saying that the officer who filled out this paperwork is colorblind? Because there is a difference between a brown-skinned man and a light-skinned Hispanic. And even a light-skinned black, okay? There's a difference. And to pretend like that doesn't exist doesn't help your argument.
I'm not disputing that there is a difference, Your Honor. I apologize. I'm simply saying that in terms of these descriptions and in terms of the possible opportunity of those witnesses to observe the individual, the detective observing the individual just in passing while he processed the arrest, these are not hugely significant differences. The Hispanic descriptor may have been checked in error, as that officer stated. To get to the hospital photos, the court actually explicitly declined to characterize those photos as Brady. The court noted that no evidence existed showing that they either depicted the person Vargas saw or any evidence about that. The court also noted that defendant's request for a mandatory adverse inference charge was not supported by the case law and gave defendant the remedy prescribed by the Court of Appeals in Handy, which is a permissive adverse inference charge which mitigates the harm to the defendant without terminating the prosecution. And I just want to highlight for Your Honors, for both of these two evidence discovery claims, defense had other avenues to elicit this information, but he elected not to do so. Instead of calling Thomas Curry, he could have called Rafael Ruiz, who was available to testify and was one of the individuals that the officer jotted down in his memo book as being present at the scene at the night of the shooting. Instead of insisting on the photos, he could have called the nurse who wrote the note in the progress report or the hospital police who responded. He chose not to do so. Defense's strategic decisions cannot transform the unavailability of one witness and the people's inability to produce these specific photos into a Brady violation, warranting dismissal of attempted second-degree murder charges, especially since the court, in its sound discretion, fashioned appropriate remedies to mitigate any possible prejudice to defendant. And if Your Honors have no further questions, the people respectfully ask you to affirm.
Thank you.
Respondent can call this a purported Brady violation as many times as she would like, but the fact of the matter is, in her brief, she says, regarding the three witnesses, this was Brady material that was required to be disclosed. And it was, and that's
why wasn't Rafael called?
A few things on this point, Your Honor. First of all, Mr. Ferguson was entitled to call one of these three witnesses who didn't happen to be related to the complainant. It was his right to be able to call whichever of those witnesses he wanted to. And the fact of the matter is, counsel didn't speak to Rafael Ruiz. And so to say that he made the strategic decision.
Rafael helped Curry carry the victim into the Jeep, right, to then drive him to Lincoln's hospital.
Yes, Your Honor. They both, all three witnesses, Rafael, Virgilio, and Curry, saw the same thing. They described the same person, a person who does not look like Mr. Ferguson. And Mr. Ferguson was entitled to not call the complainant's two brother-in-laws to put that exculpatory evidence on. And just moving on to the hospital piece of information, the only reason we're speculating about what happened at the hospital is because the police and the prosecutors got rid of all the evidence. A nurse wrote down that the complainant said he saw someone in the hospital who looked like his shooter. Pictures were taken. The complainant was interviewed 2 times, and those interviews had to happen in writing because he was intubated at the time. None of that existed, and he couldn't have called the hospital police officer because that hospital police officer retired, and the prosecutor wouldn't give him more information on how to find him. So for all of the reasons in our brief, we respectfully request that this court reverse the conviction and dismiss the charges, or alternatively, at least remand the case for either the 330 or 440 hearings. Thank you.
Thank you. Thank you both.